Caitlin, if you'll read the public disclaimer into the record.
Okay. Notice of the November 12th, 2020 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 30th, 2019. Additionally, this month's agenda has been posted on the website since Friday, November 6th, 2020.
Thank you. And now for the record, if you'll call the roll.
Yes. Okay. Commissioner Joe Begley.
You're muted, John.
Commissioner Joe Begley.
Here.
Okay. Commissioner Jeff Diaz. I thought I heard you.
Here.
Commissioner DJ Ferris.
Here.
Vice Chair Marcia Frank.
Here.
Commissioner Steve Glenn.
Here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett.
Here.
Chairman John Greaves.
Here. Okay, we have a full complement of commissioners, so we're ready to get this show started. Stacy, without asking you again in advance, would you mind leading us in the prayer and the pledge?
Which is first, prayer or pledge?
Let's go with the prayer.
Okay. Dear Heavenly Father, I thank you so much for this day and for this opportunity to be together. I thank you for all of our health and our safety. I ask that you be with those who are sick, give them quick healing, give us wisdom and discernment in the decisions that we make today. Help us to love each other as Christ loves us, and just continue to heal the division in our country and help us going forward. In Jesus' name, amen.
Amen. Amen. Everyone, please stand.
I pledge allegiance to the flag and to the
United States of America.
And to the republic which stands one nation under God, indivisible,
Under God, indivisible.
Thank you, Stacy. All right. Anna, let's get this statement of necessity out of the way.
Okay. This is an electronically scheduled meeting of the Tennessee Real Estate Commission. Notice of this meeting was posted to the Commission's website on Friday, November 6, 2020. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code Annotated Section 8-44-108B2, which states that a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code Annotated Section 8-44-108A3 defines necessity as matters
clothes can turn on you. Switch to our
and matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. As stated, this is a previously scheduled meeting of the Tennessee Real Estate Commission that is now being held via Cisco WebEx. The purpose of this meeting with members attending by Cisco WebEx is to conduct regular business of the Commission, including but not limited to the education report, executive director's report, and complaints. Furthermore, it is necessary for this meeting to be held electronically in accordance with Executive Order Number 16, issued by Governor Bill Lee on March 20th, 2020, and further extended by Executive Order 65. issued on October 28th, 2020, to ensure government continues to function open and transparently during the COVID-19 emergency, while taking appropriate measures to protect the health and safety of citizens and government officials. Voting will be conducted by roll call.
All right, commissioners, we need a motion and we need to adopt a statement of necessity to go forward. Is there a motion?
So
So
moved.
moved, Mr. Chairman.
Moved.
I got Jeff Diaz making the motion and DJ Ferris seconding the motion. Now, Caitlin, we haven't talked about this, but I bet we're going to have dozens of roll call votes today. And you guys have tried to be formal and proper in calling everybody commissioner and chair and vice chair as you read the name. What if you just called either Mr. or Mrs. in their last name? It would shorten it. It's just a little bit, but I'm trying to keep this thing short. Are you comfortable doing that, Caitlin?
Yeah, I mean, I can just say the name. I think that might be easier.
Yeah, I don't care how you do it, but we don't need commissioners or titles. See how,
Okay.
see how brief we can make that.
Okay, Joe Begley,
Aye.
Dixie,
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Frank,
Aye.
Steve Glenn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grease.
yes. All right, so the statement of necessity has passed, and so we're going to move on with the meeting. First, we have to approve today's agenda. Is there a motion or additions or corrections anyone would like to make?
Move to approve.
I've got a motion by Ms. Frank, seconded by Mr. Diaz, that the agenda be adopted as presented. Discussion. All right, let's vote on that, Caitlin.
Okay, Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Frank,
Aye.
Steve Glenn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grease.
Yes, so the agenda is approved. I'm going to go to Anna for just a second. So on the agenda, we have a 1:30 time slot for a rulemaking hearing. Most of these commissioners have never been or participated in a rulemaking hearing. Is the time flexible? I mean, if we finish early, can we go to it, or do we have to start it at 1:30 Central?
Since it was noticed at 1:30, I think that's when we have to start it. I was anticipating that we might have time for a lunch break before that and then come back and do the rules.
And would you mind just giving us a brief preview of what a rulemaking hearing looks like?
Sure. That's actually something we were going to go over in orientation, but I'll go ahead and just give a brief overview. So we have two sets of rules here that are going to be presented. One is a change to the advertising rules. The second is going to be a change to the criminal conviction section of the rules. And so there is a script that we have to follow and go over the rules, and we have a few public comments that are already here and in the record that I'll read, and we'll solicit comments from the public if they have any about the specific rules. And if they do, they will be allowed to speak, and then the commission will, after each public comment that's given, I'll ask the commission if you have any comment. During that time, it is your opportunity to just kind of explain on the record what you think about the comment and give your opinion. And then following that, we will go through some of the information that is required to put on the rulemaking form that's required by the Government Joint Operations Committee and for the Secretary of State's office. So we'll have a court reporter here that will be here at 1:30. I've already provided a list of names of the individuals that are going to be at the hearing, potential names. So you have your red line copies available, and I will place, and typically, Chairman Grace, we had people sign in on a table, but instead I'm just going to have individuals sign in via the chat box and monitor the chat. And so if I see their name there in the chat, then I will call on them for comment.
So for people just trying to figure out what their afternoon looks like, do you think in the best circumstance it will take at least an hour?
I would like to say an hour maximum. It really just depends on if we receive any other additional formal comments from other people. So an hour is the longest that I would hopefully it would go through.
And of course, that assumes we finish our regular business before then. If we have to,
yeah. But
at 1:30, if we're still working, we have to interrupt our business to go to rulemaking.
No, we can, if you're still working on your business, we can just delay it. We can't start before 1:30, so we can start afterwards.
Okay,
because that's when the court reporter will appear.
I appreciate the explanation. Next up is to approve last month's minutes. Is there such a motion? DJ Ferris makes a motion, Steve Wynn seconds. Discussion. Let's vote. Caitlin.
Okay, Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris, Marcia Franks,
Aye.
Steve Gwynn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Sorry, aye.
I think we've got an aye from Stacy. John Grease.
Yes.
Okay.
Okay. Minutes are approved. Next up is an attempt by staff to orient commissioners.
Really quickly before we do that, Pam is on the line and wanted to introduce a new staff attorney. So I figured I would let her do that quickly.
Do you want us to vote on whether we want to let that happen or not?
No, I don't.
Okay, go ahead, Pam.
Good morning, everyone. Thank you, Chairman Grease. I wanted to take a moment to introduce Pamela Valter. She's on the line with us. She just recently started with the department, and she will be one of the disciplinary counsel with Shalane. She was with the city attorney's office in Clarksville before joining our department, and we are happy to have her. And I see her on video if she wants to take a moment and introduce herself to the board.
Go ahead, Pamela. Hit your mute button.
Okay, I'm getting used to the virtual world, as I'm sure all of you are too, in these crazy times that we're in. But yeah, this is, as Pam said, I'm new to the department. I'm an assistant city attorney in the city of Clarksville up until a couple of weeks ago. And before that, I've represented governmental entities for Tennessee Municipal League for the majority of my legal career. And I'm really excited about this. It's going to be a great opportunity to be involved in public service, and I'm really excited to working with you all and getting to know you all, and I'm learning a lot, trying to absorb everything, but you know, it's going to be great. So thank you for the opportunity to let me work with you.
So Pamela, would you please spell your last name? All I see is VAW.
It's VAWTER.
Thank you. And we're glad you're with the department, and we look forward to working with you.
Thank you, sir.
Are you like a litigator? Is that going to be your role?
Yes, I believe predominantly yes. So that kind of fits in with, like I said, for a number of years, I defended governmental entities, municipalities, city employees, city officials, when they were, sued for all the things that you can sue a city for TML. So this will be more on the administrative level, but I'm really excited about it.
Perfect. Well, you should feel free to call us with any questions, and we'll do the same.
Thank you. I appreciate that.
Thank you. All right, Pamela, Spicer, anything else right now?
No, thank you.
Thank you. All right, now to commissioner orientation. Who's doing this? Anna, you and Caitlin tag teaming, or how's this going?
We are going to tag team it. Anna and I have worked together to go over. We sent the commission a PDF version of the board member orientation. We thought this would be helpful to go over, one, considering we've had some confusion recently, and then two, when you do get this, you have not even participated in one meeting, so it's really not relevant to you at the time that you hear it, because you haven't yet participated in a meeting. So Anna and I have about 7 sections that we're going to go over. And please stop us at any time with questions. So kind of just to start, the ultimate goal of the board and the department is consumer protection. That is the basic role of the department and the commission, is to protect the consumers of Tennessee and that are doing business in Tennessee. And therefore that should be at the forefront of all decisions made. Next, Anna was going to talk a little bit about the standard of ethics. So I will turn it over to her.
Okay, so as we know, it's important for board members to maintain a standard of ethics while they're serving on the boards. And there are a few highlights that we would like to bring your attention to. One is the golden rule. So it's important to treat all members of the board and people that come before the board with respect and dignity. So the board member should not let any kind of personal feelings toward an individual interfere with their decisions. Also, it's important to remember that there are certain protected classes. So certain topics are not necessarily appropriate for discussion, especially in a public setting. These topics include protected classes such as gender, race, color, national origin, and religion, and other sensitive topics such as marital status, children, creed, sexual orientation, religion, disabilities, and health conditions. So I just wanted to follow up on the health conditions one. We do occasionally get questions or medical waivers. So we would just, I don't think we have any issues with the process that we're going on with our medical waivers, but there's a slight exception there. Always keep in mind that the goal of the board or the commission is to serve the public, and board members should not use the commission as their personal platform or push forth personal agenda items. Decision making is part of the board's responsibility. So a board member should not hesitate to let anyone else or staff members know when more information is required prior to participating in a board decision. So if there is something that you would like to know more information about, as we do like in complaints or informal appearances, don't hesitate to bring that information up. Always, we want you to be the most informed in your decisions. So ask questions when you need to. one of the big topics that we wanted to discuss is like conflicts of interest. Every year, as you all know, you annually fill out a conflicts of interest statement. And in that statement, you're required to place any conflicts of interest that you might have. So I just want everyone to remember that those are filled out at the very beginning of the year. So if anything changes during the course of your service during the calendar year, please be sure to let us know so we can make sure those forms are up to date and as current as possible. So we want to make sure that board members avoid all knowns of conflicts of interest in connection with matters that come before the board. So for example, if there's a complaint that you have either been approached by another individual, they're like, hey, I have this complaint, then that someone told me about, it's important to let me know, let Shalina know if you have further if you've been contacted about this, so we can just let you know, hey, number 24, you should probably recuse yourself from. Or if you hear facts that sound similar to something that you're aware of, then you recuse yourself from that matter as well. The standard that we're looking at as to whether you should recuse yourself is whether you can be impartial, or if you think you can be impartial, then you can proceed. If you are concerned about it, then I think the safety part would just go ahead to being recuse yourself from a vote. So another topic that I wanted to discuss about is communication with board members. So everything must be discussed, deliberated on the record. It is prohibited to discuss board business outside of the official board meetings via writing, telephone, electronic communication, in-person interactions, or through any other method of communication. Communication with the public. Sometimes, as you know, licensees may approach you with requests for information. It's important to avoid engaging in the discussions and refer all of those concerns to Caitlin. If they're asking about a specific status of their license, it's good to go through Caitlin, or if there's another issue that pertains to legal, you can send those to me, but it's a good idea to distance yourself from those. Also, very important to remember that board members' authority to speak on behalf of the board during private conversations is limited. So the board should keep in mind to remind the public that any statement made during an outside of a board meeting does not result in a collective action by the board. So that would be if you were presenting at another kind of conference or anything, you cannot speak on behalf of the board. You can just give your own kind of personal opinions, but make sure that you aren't speaking for the Real Estate Commission. One thing, the board staff, communication with board staff. So I would encourage the commissioners to avoid becoming involved in the daily functions of the board office. So if you have any questions concerning anything that would need to be discussed with board staff, again, I would refer those questions back to Caitlin. And then one thing that happens, but not very often, but in case it does, gifts. So the state law prohibits board members from accepting or soliciting anything of economic value, such as a gift, gratuity, only because the board member's position with the state. So if someone was to give you a gift of any kind, just run that by me, and then I can go over the gift policy that we have in place with you. Does anyone have any questions about that section? Yes, Steve. You're muted.
So if I'm interviewed by the newspaper, let's say they're asking questions about the office market, and in my capacity as Vice President Colliers, the reporter puts that in there, but he also looks up on the website that I'm a member of the Tennessee Real Estate Commission. He can't, I mean, should I clarify it on the front end, or should I not say anything? And if he puts it in his article, I don't want it to come out as I'm representing the real estate commission in my opinion of the office market. So
Right. For that, I would clarify on the front end that you're not speaking for the real estate commission, but also since you are speaking with the media, I'd run that by our office first too, so we can get the communications office involved, so we can make sure that everything goes accordingly. We just want to make sure we follow all those parameters.
All right. Okay. Thank you.
Yes, Marcia.
We have, I was gonna.
Oh, go ahead, Caitlin.
Well, I was just gonna say, you guys have not met, but we have a whole communications team that fields any kind of news requests that come into the department. And so they're always helpful, just even as an FYI, to let them know that you've been asked, give an interview and that sort of thing. So you can always run that through me, and I can connect you with our media team.
And in my tenure as a commissioner, I've never come in contact with anyone wanting to give gifts. But when I received this orientation, I actually read it. I read all this stuff. I wonder about, usually when we go to East Tennessee or West Tennessee, we're invited by the association in that area out to dinner. And I was wondering, is that considered a gift? They usually invite the whole commission and attorneys and Caitlin and everybody. But I just thought I should ask your opinion on that, Anna.
So when you have issues with like perishable items such as food, we have certain provisions for those. And I think that would kind of fall into the policy of, if it's something like food that's given to you that would maybe be awkward to turn down, then we would just need to report it back to let the ethics officer know that we this while we were there, dinner and lunch was provided.
Okay, thank you.
You're welcome.
Okay, Caitlin.
Okay. I'm going to talk a little bit about habits of effective board members. And if you are following along, this starts on page 9 of the PDF that was provided. So as a board member, it's important to be prepared for the meeting and read all of the documents in advance of the meeting. Doing any outside research is not appropriate. As a board member, you're like a jury. So just consider yourself sequestered and only given the information that is provided to you. And you kind of have to trust the fact that our attorneys and the board staff have done the research for you. Obviously, if you have any questions, it's always appropriate to ask that of legal or myself, either directly prior to the board meeting or at the board meeting. We want board members to be able to participate. So if you need additional information, we're always happy to provide that in order for you to make your decision. I was going to talk a little bit about the budget. So we do provide the commission with the budget every month, but it's important to note that the commission doesn't need to get involved in the day-to-day of the budget. This authority remains with the legislature. I also wanted to talk quickly about public records and open meetings. On page 63 starts a PDF of the open meetings. There's an open meetings PowerPoint. This also goes in line with the Sunshine Law, which I'm sure you've heard us mention. Essentially, it means that all board deliberations where there's 2 or more members present must be in the sunshine, meaning they must be in front of the public. This means you can't discuss anything with another board member related to board business unless it's in front of the public. This also does include emails, phone calls, text. This is why you'll notice that we always blind copy the commission. I know many of you have asked me, did this go to everyone? We do that so that there's no chance that you could reply all with any questions or opinions that you may have. Electronic communication is not considered a chance meeting, and so it should be avoided at all possibilities. This is getting into the administrative part, but we do notice all meetings on the website at least 7 days in advance, or as soon as practical when it's a more emergency type meeting. And then I just want to talk a little bit about public records. It's our goal to be as transparent as possible. And per the Public Records Act, all state records are available for public inspection. This includes applications, emails, complaints, and it can even include text messages if it's related to board business. So it's important to keep that in mind whenever you're emailing about board business, that it could later be subject to a public records request. Those are the main points that I had for just habits of effective board members. Obviously, participation is important and attendance is important. Per policy, you must attend at least over 50% of the meetings, and we must have a quorum, which is at least 50% or more of the members. So any questions about any of that? Okay, we were going to talk a little bit about restraint of trade and anti-competitive practices. In 2015, and Anna, I don't know if you want to start this or if you want me to.
Sure, I can start it. So one of the cases that we talk about regarding unreasonable restraint of trade is a Supreme Court case from 2015, North Carolina Board of Dental Examiners versus the Federal Trade Commission. So what was held in that decision was that the board members may not be subject to immunity for actions of the board if their actions are considered to be anti-competitive. So there is basically a Hello?
I'm trying to get on a meeting. I guess I'm not really sure what's happened. Sorry.
Okay. There was a two-pronged test that came from that court case. Sorry, it was that the state action immunity from federal antitrust liability, anti-competitive conduct is protected if one, the challenged restraint imposed by a non-sovereign actor is one that's clearly articulated and affirmatively expresses state policy, and two, that the policy is actively supervised by the state. So in response to this, we enacted Tennessee Code Annotated 4-4-126. That's basically means that we have our policy director that reviews all of the board meetings. And if they see an issue that possibly could be concerned with unreasonable restraint of trade, that issue will be flagged and we'll catch it. But also, I will be monitoring to make sure that we're not going into that category as well. So if there is an issue, it may require action to be corrective action by the board to come back to that. So normally any action that happens within the board meeting, happens in the course of board meeting, board members are protected from personal liability. But if it was to be deemed anti-competitive or not follow those two prongs, then you're subject to personal liability. So we always make sure that what we're doing and monitoring that we don't try and regulate more than what our statute allows. And if you ever have questions about it, you should always direct them to me or Caitlin.
So
I was just going to add that starts on page 34 if you want to read more about the Supreme Court ruling on that. And I know when we first started this process, I know it was not a positive thing for many people, but it really is meant to protect all of our boards and commissions and make sure that they're not doing anything that would potentially put them at risk for personal liability. So if there ever is a decision, that's when we would have an emergency meeting, or that's when we would have the commission re-review that decision, just to make sure that we're not getting into anti-competitive practices.
So Anna, rather than me read that section, could you give me like an example what might qualify?
So I can give you the example that came from the case. So what happened was it was the Board of Dental Examiners, and they wanted to regulate teeth whitening, who could do teeth whitening processes or not. And they were ultimately ended up regulating individuals that did not fall under the jurisdiction of that board. So if we were to decide to regulate someone that doesn't fall under the jurisdiction of the real estate commission, that would kind of be considered that issue. So whenever we tell you that something does not fall under jurisdiction or not, that would, such as we cannot regulate the practices of third parties that may be included in regulation, may be included in some of the processes that our agents or licensees undertake. So that's kind of what it is, what that would be. So we're trying to make sure that we do not regulate anyone that would fall outside of our purview. Typically, I haven't really seen that happen with this board or commission, but it's kind of hard to explain unless you kind of see it.
So Anna, can we regulate people who don't have a real estate license?
If they are, you can regulate, so for example, unlicensed activity, if an activity of somebody falls under the definition of brokering or anything that's in our statute, then you have the authority to assess civil penalties for being unlicensed. But if it's actions that do not fall under the definition of broker or anything clearly in our statute, then no, we could not regulate that.
Marcia?
So, John, I was going to say the only thing that I have seen come up under this is HOAs. The Real Estate Commission does not have purview over HOAs. So whenever something about an HOA, there's a complaint, we don't hear it. And that's usually stopped before it even gets to the commission.
Good example.
Right.
Thanks, Anna.
You're welcome.
Go ahead.
So we do look at those, like if I do look at complaints that come in that may or may not fall under the jurisdiction of the commission. So those usually come to me beforehand, and I'll make that determination beforehand.
Does that complete the orientation?
Not quite. Not
okay,
quite.
well, let's keep it moving.
Yeah. We also wanted to quickly talk about the Fresh Start Act. This comes up from time to time. The discussion on this in the packet starts page 59, if you want to follow along. Essentially, this applies to all registrants applying for a license. The Fresh Start Act requires that prior to the commission denying an applicant for licensure, that the commission must first determine that the conviction is directly related to the profession. And this is why when we've had informal applicants that come before the commission, that the commission may think, it's not in the best interest of the public to allow this applicant to proceed. Anna and our legal team has walked you through a series of questions. The Fresh Start Act gives an applicant that has been denied the opportunity to petition within 30 days the Davidson County Chancery Court. And if the commission has denied the applicant and walks through the Fresh Start Act and then they petition the court, the state then has the burden to show the evidence of the conviction directly relates to the profession. So that's part of the reason why we go through those series of questions, to make sure that the commission is thorough in their decision of denial and that it directly relates to the profession. Anna can talk about the more legal means related to that.
So this is actually pretty timely because one of the rules that we're amending is coming because of the Fresh Start Act. So the Fresh Start Act was really passed to allow other individuals that may have had lower level convictions to be able to essentially have a fresh start in work and enter different professions. So this kind of it was particularly targeted towards the lower level felonies and misdemeanors, so like Class D or E felonies, which are considered some of the lower level drug felonies. But the Fresh Start Act does have provisions where anything that's considered a Class A, B, or C felony, that is considered to be, there is a rebuttable presumption that it applies to the profession. So as you all know, we have what we're looking for if someone has to appear for us in informal appearance capacity. It's going to be for misdemeanors related to theft of money, services, or property. And then right now ours says all felonies. So during the rulemaking hearing, we'll be talking about that a little bit more. All felonies is pretty broad. So we're going to that's kind of like the legal background behind the Fresh Start Act. And if we ever have a Fresh Start Act initiative or issue, then I will walk you through the process. It considers there are a lot of different votes that we need to make and discussion that we have to make for the different points considered in you're making your decision. So we've done the Fresh Start Act analysis a few times beforehand. So it applies to initial licensees and also current licensees. That license may be, if someone's license is revoked due to a criminal conviction as well. Does anyone have any questions about the Fresh Start Act? Yes, Steve.
What's the time frame on the Fresh Start Act, or is there one? It's a fresh start after when?
There isn't really
day, or
there isn't really a time frame. So, you know, in our rules, there's 2 years. But we're making changes to that, so it's not really a time frame that it is. But one of the factors, if you were to deny someone their application based on the Fresh Start Act, one of the prongs actually talks about the length of time between the conviction or action and now. So that's something that we can consider whether someone is, if you decide to deny someone, but there isn't like a time or a set of years that triggers the Fresh Start Act.
The commission has made the process of only doing a 10-year look back.
Mm-hmm.
So
how much?
we are
10?
looking at any felony 10.
10.
We are looking at any felonies or misdemeanors that are related to the profession that are within the last 10 years. And then if the commission does deny someone, that person has 30 days to petition the court.
Right, and that will go to Chancery Court if they were to try and contest what we've decided. So it wouldn't come from, no further action would be required from the commission, but that if it is appealed, they're going to look at the analysis that was conducted at the meeting. So make sure if we were to deny someone, that we really do have robust analysis and comments, because that's going to help explain some of the reasoning behind it. So if you say one thing, I might try and pull more information out of you, so we can just have a really good conversation on that.
Can the Fresh Start Act not align with, let's say, a 10-year look back? We had a 10-year look back. The Fresh Start, does that track with the Fresh Start Act, or doesn't matter, or?
Right. So we're looking only at the first 10 years, like 10 years from the application. So anything before that maybe happened 15, 20 years ago, we're not going to look at that. So we're looking at Fresh Start information from 10 years from the date of the conviction or release of incarceration or probation, whichever is later. We're only looking in that time frame.
So, Anna, will it be legal's policy to make a recommendation when we get to these cases?
To make a recommendation, whether
Yes.
to
Grant, licensing, or to deny?
Right. So we haven't, we let that decision come to the commission. So if there is an individual that falls into the category of the Fresh Start Act within that 10-year look back, we're going to bring that individual before the commission with their principal broker so you can make a determination. But typically no, unless that is something that the commission would like, I'm not going to make a recommendation whether that individual should be licensed or not.
Thank you.
Okay. Any other questions? Jeff, did you have a question?
I did. I just wanted to know, I understand the clock for an applicant to appeal. What's the clock for an applicant to apply after the commission makes a decision?
To comply?
To reapply for their license or
Oh, so if your license is not granted, like if we were to not grant a license, an individual then is allowed to reapply for licensure after a 6-month waiting period. Okay, that's the Fresh Start Act, and I wanted to go through talking about disciplinary action really quickly. So as you know, complaints are presented before the commission in an anonymous fashion. We receive all types of complaints from consumers, also from industry individuals, from other entities. We do accept anonymous complaints as well. So if the complaint falls within the jurisdiction of the commission, then that complaint is going to be sent out for response. And as you know, all real estate licensees, or if anyone is real estate, if you're licensed by the board, you have to respond to the complaint within a specific amount of time. If you don't, then that's sometimes individuals don't respond. And then once that has happened, that is referred up to the legal division once we receive the response. And then our disciplinary councils will review the matter for any infractions with our rules and statutes. And that's going to be presented to you in a legal report or a consent agenda. So what we've been doing is a consent agenda, which means, excuse me, those are the matters that are considered that we recommended dismissal. And then the commission can decide to pick and choose which complaints they would like to hear more information about. And typically a legal report is where we recommend discipline. But as we're doing these virtual hearings, we put everything on a consent agenda so that the commission can just pick and choose which items that they would like to further discuss. And so there are a couple of, the legal counsel will always provide a recommendation. It is, you can decide to agree with that recommendation or make another decision. So the complaint actions include dismiss with no action. So we did find a violation, that is going to be close with no action / close and flag. So occasionally you will see us represent matters where we are unable to obtain service or any kind of contact with an individual. If that happens, then the matter is going to be closed and flagged, meaning that if that individual tries to renew their license, in order to do that, they're going to need to resolve that disciplinary action prior to renewal, which we do see occasionally. Also, we have letters of instruction and letters of warning. A letter of instruction is when an individual has violated a rule or statute, but we decided to just send them a letter instructing them of what has happened instead. And then a letter of warning is it means a little bit more than a letter of instruction. So letter of warning is going to give individuals let them know that they have made a violation and that if a violation occurs again, they may be subject to further disciplinary action. So letters of instruction and letters of warning are considered private discipline, which means these do not appear on the disciplinary action report that is produced by the department every month. If there was to be some kind of discipline assessed, then the individual is going to be sent a consent order. The consent orders are an offer of settlement. So that means that the commission has found that there's some probable form of a violation. And so the consent order is going to give the individual 30 days to accept or reject the offer of settlement. If they do accept it, then the consent order is signed, and then the matter is subsequently closed once all of the different requirements are satisfied. So anytime where we're assessing education or civil penalties, or we're downgrading a license, suspension, or revocation, those are going to be sent via consent order. And so I think it's important to remember that the recommendation that you give at the meeting is a recommendation that has to either be accepted or rejected by the individual. If they say no, then the matter will be set for a formal hearing. Depending on what subject topic it is going to be, it'll either be sitting with the commission or with an ALJ alone. Another form of action that we have would be litigation monitoring. We don't use this too often, but that's usually when the board will withhold their decision if there's pending legal action that deals with them that may use some of the issues that come up that are regulated under the chapter. So it's good to remember that this information and these complaints, they're considered to remain anonymous, so you won't know the identification of an individual. Probably if they settle, then you won't know their name, but it's anonymous as to remove bias or making unfair decisions. Also, there is another type of discipline called summary suspension. So summary suspension is in the event that a complaint is received and it's determined there's immediate danger to the public health, safety, or welfare. A summary suspension proceeding may be initiated. This process would circumvent the initial complaint review process, and the individual would remain summarily suspended until they're able to have a contested case hearing. So a contested case hearing is a formal hearing. So that is either when the individual they reject the offer of settlement, and then, as I explained before, depending on the subject matter, the commission as the jury, or it is presented to they alone. The matters for the real estate commission that are for ALJ alone would be unlicensed activity matters and errors and omissions complaints that we send out to individuals. So there are a lot of different procedures that go through with the hearings. We'll have one tomorrow. So you'll get to kind of see what goes on in a hearing, but essentially the real estate commission will sit as a jury. So you'll be able to ask questions and make decisions of how it is going. Does anyone have any questions about this disciplinary section?
So, Anna, just one point. So, say the licensee or the respondent agrees to the offer made by commission. at some point, that will become public record and the party will be identified.
Correct. So you'll most likely see that individual's name show up on the disciplinary action report. But also all of the information such as a consent order is considered a public record. So if someone was to make a public records request in response to a complaint file, then that information is going to be given out. So it's just, they're anonymous before you until there is some kind of resolution at the end. Okay. And then the last thing I wanted to talk about is rulemaking. So rulemaking is used to change or adopt rules and regulations that go along with the Tennessee Real Estate Broker License Act of 1973. So there are 3 different forms of rules that rulemaking processes. So first would be proposed rules. Proposed rules, those are presented by the commission, and there is not a rulemaking hearing. There is not a rulemaking hearing in that process. So the rules will still follow the same process. There's public comment, but there's not a specific hearing that is available to action. We have strayed away from doing proposed rules. We now mostly use rulemaking hearings. So rulemaking hearing rules are when you have a set of rules that you would like to change, and then you set a hearing that is open to the public to provide any kind of comments or changes or additions that may be made. So the process would be that the rules are drafted, presented to the commission for approval, and then they're routed for the department to get approval as well. And then it's sent to the governor's office for pre-review. And then there is a hearing, and a hearing will be before the commission and a court reporter, and we'll go through all of the different scripts and information that's required from the rulemaking hearing. Depending on what happens to the rulemaking hearing, that's when we'll make a determination of what needs to happen next. If the rules need to be amended in some form or fashion, they will be done for that. Or if there's just comments and we go ahead and proceed. And if that's proceeding, then the rules are sent back to the governor's office for post review and approval, and then to the AG's office for final review and signature. And then the rules are filed with the Secretary of State's office. And once the rules are filed with the Secretary of State's office, rules are there. They have to be noticed for a specific amount of time, and then the rules will go before the Joint Government Operations Committee at the General Assembly. And the rules then will be approved or not approved, and then they will go into effect. Another set of rules that we have very similar to this would be emergency rules. Those are for rules that that immediately have an impact on something that concerns the health, safety, or welfare of the commissioner or a topic that's brought up. So their emergency rules are only temporary to get past because there is something that's emergent that needs to come from it. But afterwards, it does have to go through the process of making it a permanent rule through rulemaking hearing processes as well. So rulemaking hearings, for rulemaking, you can the board will sometimes have issues that they will propose that they would like to be changed via rulemaking, or a member of the public can also petition for rules to be amended as well. And then you also sometimes have us, the legal department will need to make certain rule changes depending on different statutes or statutory changes that are making that impact our rules. Does anyone have any questions about rulemaking? Nope. Oh, Jeff, and then Joan.
I was just curious, once it gets over to the legislature, they're obviously going to hold some hearing or committee hearing about the rule, I would guess.
Yes.
Who would speak at that point if they have?
So that would be the board attorney would be present as well as the executive director. So whenever we go before the legislature, we usually have several pre-meetings where we discuss the rules and any kind of issues there. But then once we go and testify, typically there'll be 3 different individuals that are there. It's going to be usually your board attorney, executive director, and then the assistant commissioner will be there to answer any questions. Board members are not required to come to those, but typically when we have sunset hearings, that's when we would request a board member to come and join us. And Joan, did you have a question?
I did. What kind of time frame from the time of rule hearing today so that actually becomes effective are we looking?
So it really kind of depends. Rulemaking can take as long as a year, but usually it also can take 9 to 10 months. So it really depends on how long whether we have issues with the rules in the beginning or the end, or kind of those things. But I would generally say at maximum it's going to take about a year for rules to be approved.
Okay, and these 2 rules may not be going along at the same pace. Is that correct?
Right now they are going at the same pace because we are having the rulemaking hearing at the same time. So then following our rulemaking hearing today, I'll make changes to the document depending on what happens from that. And then it will be, both sets of rules will be sent together to the different entities. But it may be that once they get to the Attorney General's office, that one set moves before the other. But we'll, of course, let you know if that happens.
Thank you, Anna.
Welcome. Well, I don't have anything else to say. Does anyone else have any other questions about anything that we've covered today?
So I've got 3 points, but I want to save them to the end of this orientation. Are we there?
Yes.
Good. Okay. First of all, Joan, I think you could, if you had, it'd be much easier to get a law passed and quicker than get a rule approved. Okay. So if you've got somebody that's got something in mind, legislatively, it might be a better way to go than a rulemaking hearing just because it takes forever. That's my take on that. Anna, maybe Caitlin said this, but we're a consumer protection agency. How proactive can we be? Or are we just kind of like here to respond to complaints?
So I'd ask you what you mean by proactive.
Okay, I'll give you an example.
Okay.
Every day I'm hearing advertisement after advertisement from companies that hold themselves out as timeshare exit companies. And they're telling consumers on a daily basis that they can get them out of their timeshare. Well, my experience has been not through us. It may be civilly they can do it, but they can't do it through us in almost every case. 99% of the cases, a time limit is expired. All the paperwork is correct. Could this commission start sending letters to timeshare exit companies saying, hey, don't be telling people you can get them out in Tennessee because, and list a couple of reasons. Is that too proactive for a consumer protection agency?
So I think in that kind of circumstance, what we would want to do would be kind of what we do in any other kind of form of fashion is inform the public through some kind of, we can send that out via e-notify or through different kinds of talking points where we could coordinate with the communications team to let individuals to be more aware of these certain things. I do think that timeshare exit companies fall into that really kind of gray area of really, I don't think they really fall under the commission, the jurisdiction of the commission. So the best thing that we could do would be to create materials or communications that we would get out to consumers to let them know to be aware of these types of things.
Here's kind of what I
Arillo has done that for us. So they have done a lot of work on this particular topic for us to share with consumers.
So here's what I'm thinking. Maybe Arillo's handle it. But if we tell the timeshare companies that you can't do it in Tennessee, and they go ahead and take money from timeshare owners, only to be told later that they can't sell their unit. It would seem to me that consumer might have the right to go after the timeshare exit company because the exit company was put on notice that not in Tennessee. And I'm not trying to be specific, but that's kind of proactive talking about. I get what you're saying, that we be proactive with the consumer, not with the offender, but it's more of a rhetorical question than I don't need a direct answer right now. And the third thing, Anna, I like to keep track of dogs' names. What's your dog's name?
That was Ella.
Okay. I recognize Dixie up in Upper East Tennessee. I just want to keep track of these dogs when I hear bark.
So sorry.
That's not a problem. Thank you for your report. Thank you, Caitlin. I think we'll go ahead and have this informal appearance and then take a 10-minute break. So,
Marcia, did you have a question?
Oh, I'm sorry.
I just wanted to say, Arillo, this is a nationwide problem about that you were speaking of, John, and we have done two actually videos, and that's available for all real estate commissions to put on their website. I don't know if Caitlin, if that's been on there, gotten on there yet, or I'm sure our legal would need to approve it too before it does. But it does explain how people can get out of these problems. So it is a proactive thing that Arillo is helping all commissions do.
Any other comments? Let's move forward with this informal appearance. My agenda, Caitlin, doesn't tell me who to ask for. So could you give me the names of the prospect and his broker?
We are looking for applicant Tyler Wolf and principal broker Kent Ledbetter.
Tyler, are you here?
Yes, sir.
Kent, are you here? Kent Ledbetter?
I think he might have been the guy who called and interrupted Miss Anna earlier.
So we've got to have him on the call with us, Tyler. Let's do this. Let's take a 10-minute break. And if you have a way to reach Kent.
Yes, sir.
Tell him to call back in. It's the right time for him to do it.
All right. Thank you very much.
Let's come back at 1:45, which is about 8 minutes or so, but that'll give us a quick time for a break.
On your muted.
Hello.
Hello.
There, we can hear you.
Hey, Kent.
Yes.
Okay, just checking to make sure you're on the line. Hey, Mark Green,
Okay, yes.
let me go to Mark Green just for a second. Mark, you on? Mark. Excuse me. Okay, we'll come back to Mark. All right, Caitlin, we got one informal appearance today. It's Tyler Wolf, who's the applicant, and Kent Ledbetter, who's the proposed principal broker. Would you give us some background? And Kent, I'm sorry, Tyler, when Caitlin finishes her quick summary, we're going to turn the floor over to you, and you can tell us all you want us to know about you, what got you into circumstance, what you've been doing since, why you'd like to state, whatever you think would help your case. Okay?
Yes, sir.
Okay. Go ahead, Caitlin.
Okay. Before you have applicant Tyler Wolf and his principal broker, Kent Ledbetter. Mr. Wolf has taken the Tennessee Real Estate Affiliate Broker exam. A summary of the sanction is felony sale of cocaine. Mr. Wolf's statement and a letter of recommendation can be found in your packet.
See, Tyler, I told you to be brief. So we'd like to know the history and anything else about you can tell us.
Well, the charges that were presented against me happened when I was 21 years old. Since then, I'm 28 now. I manage a restaurant, and I'm trying to find another way of income to help me and my family. Since the charges, I've done nothing but kept my nose clean and kept my head low and just trying to progress at this point.
Okay, commissioners, any questions you'd like to ask Tyler? Marcia.
Good morning, Tyler. I wanted to ask, why is it that you've chosen real estate to get into?
I realized after working in restaurant business that I love working with people. I love humanity, and I like to see people happy. And I would like to make a lot of people happy through real estate by providing them a home or helping them sell their home. Also, I've chosen it because I've seen that it can be a lucrative way to make a large amount of money for my family, because I'd like to provide my children the stuff that I never had growing up.
So are you presently working at a restaurant?
Yes, ma'am. I'm in a restaurant here in Knoxville.
Okay. And how do you know principal broker Ledbetter?
Actually, through trying to pursue a real estate career. I met with him. I've talked with him a few times, and just gotten to know him over time. And he finally sat down with me and said that he would help me out.
Okay, that's all the questions I have, Mr. Chairman.
Other commissioners? Okay, the questioning or the statement that goes to principal broker Kent Ledbetter. Kent, why do you want Tyler, or do you think he'd be a good fit for your company?
Yes, sir, I think he would. I've met with him and we've talked several times. He seems to be very family oriented, so I don't think he is anything like what happened when he was 21. I'm familiar with the restaurant that he runs, and it's a pretty nice place. And so I think that with his sphere of influence and everything, that I think he would be a good candidate for a real estate agent.
Okay, questions for Kent? Jeff.
Hi, Ken. I just wanted to know, I saw in the paperwork where you say you supervise 325 other agents.
That's correct.
I wanted to know kind of what structure you have in place to make sure you supervise Tyler begin his practice of real estate.
We have, I have a support staff of 7 folks, and I have a quality control that looks over the paperwork as it comes through. I don't turn my phone off. I work 7 days a week. I take phone calls all the way to 10 o'clock at night. The support staff I have it's sort of like a quality control. They don't have direct any supervision. I do all the supervision, but they take a lot of the normal clerical things off of me. They look over the paperwork, and then I look over the paperwork. If that way, it gets more than one set of eyes. But I think the biggest thing is I don't turn my phone off. I work 7 days a week. Of course, I guess principal broker, you need to work 7 days a week. If my agents are working, I'm working.
Marcia.
I'm in the office. I'm available. I also have 2 coaches that help with the things that sometimes the principal broker would do that are not regulated. Things like helping them with their sphere and getting started, and all of the things that sometimes are non-regulated things that are on principal broker. I have 2 coaches that handle that. So my position really is pretty much strict compliance.
So, Mr. Ledbetter, this is Marsha Franks. I wanted to ask you, we just have here, it's Keller Williams Realty. What is the full name of your company?
The LLC is Knoxville Premier Properties, DBA Keller Williams Realty.
Okay. And so you say you have coaches. How do you, have you trained the coaches yourself, or how does that work?
Well, the coaches do not interfere, or they do not they don't do anything with compliance. I do work closely with them. They're in the office every day. What they do are the things that like help with sphere of influence. They help with how to generate leads, and everything that they do as far as advertising, I review everything. And so if they have any flyers for open house or anything like that, I review those. But the coaches, yes, I work closely with them.
So
mostly they only deal with unregulated activities, just to help the folks get started.
So who will be instructing Mr. Wolf on how to write a contract?
Oh, I will. Yeah, I have. We have classes daily, usually 3 to 4 classes a day. I teach the contract classes. Especially any of the writing of contracts. That's strictly me.
Okay, and how did you meet Mr. Wolf?
Well, I met him sort of indirectly through the restaurant. And then when he came in and talked to me, talked to our team leader, then that's when I really got to know him. So will Mr. Wolf be on a team? Well, I'm not sure. That may be up to him. That would be up to him. If he wants to be on a team, that would be his choice. I think it would be a quicker track to be successful because of the leads that he would be receiving. What kind of real estate will he be selling? Well, he'd be selling strictly residential. Okay, that's all I have, Mr. Chairman.
Other questions? If not, is there a motion? Oh, Joe Bagley, go ahead, and then Joan.
So Tyler, how do you work in 2 jobs hour-wise, or I mean that restaurant? How do you think you can give your real estate clients the kind of service you need? I mean, can you take calls during the day from other agents asking for questions and paperwork and stuff while you're at the restaurant, or are you going to just stay? You're going to do both jobs, I guess.
I would do both jobs until I can get my feet off the ground with real estate. I manage the night shift there, so I go in the evenings. So I will have from 6 a.m. until 5 in the evening to deal with anybody who needs me directly or indirectly. That's always been my layout for now. Is just to keep going until I can only do one or the other.
Okay. Sounds good.
Okay, Joan.
I think he answered my question. I was concerned about how he would receive his training with working at the restaurant.
Okay, is there a motion?
Mr. Chairman, I move to accept this applicant.
Thank you, Jeff. And Ms. Frank seconds that motion.
Second, yes. Yes.
Okay, further discussion. Tyler, if this vote turns out on a positive note, then you're free to continue on to get your license. If it doesn't, then you may have to come back in 6 months. But let's be positive. Caitlin, let's call the roll.
Okay, Joe Beckley,
Aye.
Jesse Yaz,
Aye.
CJ Ferris,
Aye.
Marcia Frank,
Aye.
Steve Glenn,
Aye.
that was an aye. Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Creed.
Yes. So based on my Farragut High School education, that motion passes.
Thank you guys very much.
Good luck, Tyler.
Good luck, Tyler.
Thank you guys very much.
Thanks, Ken.
Thank you, sir. Have a good day.
Mark, you too. Mark Green, are you with us?
I am. I was with you earlier, but I couldn't figure out the mute button. Apparently, it's more complicated than I am smart. So,
Well, that's what I wanted to talk about. So I've seen some recent correspondence that's come from your desk with your signature on it that appeared to me to be brilliantly written. And I just wanted to either congratulate you on that or let you know that whoever you signed that letter writing to did a great job.
that would be Miss Matlock. Again, again, my intellectual ability is somewhat limited, but Miss Matlock, the sky's the limit.
I think that's right. It took us a while to get you to agree to write a letter to the, who did we send that to? The State Attorney General?
Yes, sir.
And it was crafted spectacularly. And so I don't know if we'd have that on the agenda, but I wanted the commission to know that the request to get a letter up to get an opinion on a particular topic has been sent to me. I reviewed it. I was impressed. I signed it. And I don't know where it is now, but I've emailed it back to Caitlin. So I think it's in progress. And I appreciate, Mark, your help.
The process.
Your help and Anna's as well.
Absolutely.
No,
You're welcome.
just guessing. Do you think we'll get an answer in like 6 months or 2 months or next year? Or what do you think when Herb Slattery gets a hold of something, how long does it take? Just guessing.
I would expect to hear something maybe by the first of the year.
Good.
Just unless something held it up, or the general usually, he assigns it to a deputy over there, and then it goes back to his office, and then they either agree or disagree. And so I have seen that process take several months, but I'm anticipating we'll get an answer back, hopefully, by the first of the year.
Perfect. Well, thank you for your help with that. Are you on this line for any other reason, just to listen to us, or do you have any other thing you want to discuss?
No, sir. I am just listening. I've got another meeting in about 45 minutes, but I'm just here observing.
How do you think it's going so far?
I was very impressed with the orientation. I thought it covered a lot of valuable topics. Thought it went
That's
well.
it? It's the only thing you were impressed with?
Well, I'm always impressed with everything that the board takes up.
Thank you. Thank you.
But yeah, no, I think the meeting's going well.
Thank you. You feel free to chime in anytime. We're going to move on to the education director's report. E. Ross White.
I'm here, Mr. Chairman. Can everybody hear me?
Loud and clear.
All right. I've got a little sinus today, so got a deeper voice, but I have the right spirit. Anyway, greetings on this beautiful November morning, and hope everybody's doing well. I want to present to you the education report this morning. It's fairly short, and I want to say that I've reviewed all the providers, the courses, and the instructors, although I didn't have any new ones to report today. And they should be before you now. And I would report that they all comport with the laws and the rules. And for your approval, Mr. Chairman, members of the commission. Oh, that's N1 through N20.
You're muted, John.
I'm sorry, you muted.
Education myself. So courses N1 through N20 are recommended by the education director to be approved by this commission. Is there discussion on a particular course, Marcia?
If I could just ask a couple of questions about some of these classes before we vote, I won't have to withdraw them and then individually discuss them. It might go faster. Okay, so I'm wondering on N1, Mr. White, this is a class about Airbnbs, and it's a statewide, where this instructor can teach this statewide. So I'm wondering about their experience and where did they learn about it, about Airbnbs?
Well, I have to say just from the outset that Ms. Aquanetta Harris has been in the business there in Memphis as a provider for many years. She's done her own independent study on Airbnbs. And so her course reflects what she understands about it and the market. I don't have any specific things to say other than that, but I am convinced that she can put this course on.
I'm wondering, Mr. White, because of the differences, there are local jurisdictions over Airbnbs. So, for instance, the rules in Nashville are not the same as the rules in Franklin, just one county over. So I'm wondering, did she take that in consideration when she teaches a class statewide, that the jurisdictions go to those local boards and commissions, and so it's all over the place. I just worried a little bit about someone teaching a class who knows the market in Memphis, which I'm sure she must. But Knoxville, Johnson City, those markets may be different. So that was my only concern: is are you satisfied with, after seeing her syllabus, that's included?
Yes, Commissioner.
Okay. The next one I have a question about, on N2 and 3, those are both 10-hour classes, and I just wanted to make sure that there was enough content for there to be 10 hours credit for the CE. Did it appear so to you, Mr. White?
Yes, ma'am. Commissioner Franks, I believe that the information would include that she has enough to put that much on as far as her education course.
Okay. On N4, I'm wondering, is this person a principal broker? This is a class on when you own your own company, how you run a company. And I'm wondering if this person is a principal broker or has been a principal broker in the past that would know how to run a company.
Hang on just a second. Trying to find that.
She is.
Okay.
Thank you. Yes.
Okay. On N5, has this person taught the core class before?
Hang on just a second. N5. Yes.
Okay. Okay. That's all the questions I have, Mr. Chairman.
Thank you, Ms. Franks.
Other questions? If not, is there a motion to accept or to adopt the Education Director's recommendation and approve courses N1 through N20?
Move to approve.
Mr. Diaz makes a motion. John Moffett seconds it. Discussion. All right, those in favor of the motion will vote aye when Caitlin calls your name.
Okay, Joe Begley,
Aye.
Jeff Diaz, DJ Ferris,
Aye.
Marcia Franks,
Aye.
Steve Glenn,
Yes.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grease.
Yes. Okay, so the motion passes. What else, Ross?
Mr. Chairman, just want to give you a status on the renewal process. We're in that renewal process now, and I've reviewed and approved the courses over 1,000 so far for all the various providers and instructors that we have in our education program, and everything's going good, looking good.
So will we have to approve all 1,000 courses?
No, that's already been done through the system after I review what they've sent in and been sure that the information is there, then I approve them. There are courses that they already had that they've put forth for renewal.
Okay, I have one more question. So maybe some commissioners may not know this, but this meeting is approved for continuing education, like 8 hours of continuing education. Have we had anybody sign up virtually to take this course, to be here for the length of this meeting and get 8 hours of continuing education?
I haven't been given that list. Now I think that goes through our excellent staff, Aaron Smith, and I would defer to him on that one.
Aaron.
Good morning, Commission.
I thought you'd never talk.
At this time, we haven't had anyone to sign up and request the CE since we have been in the pandemic.
But
virtually.
But it would be easy to do, and you could monitor it, I guess, couldn't you, Aaron?
If they contact me, yes, that is something that we could keep up with and see to stay in compliance. Yes, sir.
Okay, the only reason I mentioned this is I think Anna at one point this morning talked about in case you individually are talking to a group, and let's say it's a group of real estate agents, feel free to tell them that they can get 8 hours of continuing education by just being in attendance at this meeting virtually. And it's a pretty smart way to get 8 hours of continuing education. There's no test. As you know, some days it's only at 2 or 3 or 4 hours, but the way it's set up, 8 hours of CE. So please keep that in mind. Any questions about that? All right, let's move on to the Executive Director's report. Caitlin.
Okay, I have a pretty short update for the commission. I mainly just wanted to point out that licensing numbers are still up. For October, we approved 627 initial applications. That's over 100 from the prior year, a little bit down from September, but overall still going up in comparison. And then the other item that I wanted to bring to the commission's attention is a request that Steve Glenn made last month for an overview of our complaints and those in formal hearing status. So right now, the commission has 363 complaints open. And what our goal is to close out all complaints within 180 days. So 363 is actually, it may sound big, but when we have roughly 70 complaints getting opened each month, and our goal being to close those within a 6-month period, 363 is really a very good number, and our legal team has done a great job of getting those cases moved. Right now, we have 70 complaints that are open and over 180 days, but that doesn't mean, those are probably cases that you have already heard, and they're in either a payment plan status, formal charges authorized status, litigation monitoring status. There's a lot of different statuses besides just open and over 180 days. Of the 78, 34 are in formal charges authorized status. 5 are set for a formal hearing, and 5 are formal charges filed, which means that they are not coming before the commission, that they'll come before an ALJ alone. So they're probably either unlicensed activity or there are E&O complaints. So that's kind of a small picture of what we have as far as open cases. Any questions? Yep.
Marcia.
I was wondering, I noticed from the minutes that you were going to give us a report on the status of the Kentucky reciprocity agreement. Any news on that?
Yes. So I have had a meeting with the director of the Kentucky Real Estate Commission, and I presented those changes to you guys last month. After I presented it to you, I sent it to him for his commission and department to review, and it is currently still with them. It'll still come back before you again before anything is finalized.
Okay, Steve.
This is maybe a question for Caitlin and or Anna. As it relates to the cases, it seems like every month there's complaints where we don't have jurisdiction, meaning it's a problem between a buyer and a seller, and the real estate agent's really out of the deal. When a person calls, is there a conversation on the front end? How does it work to essentially not have to spend however long it takes to listen to all that and then write it all down and then make a complaint or put it down on our list when it may be confusion by the person calling in that they think they have a case against an agent, but it's about them and the seller or vice versa. See what I'm saying?
Anna, if there's a question of whether we have jurisdiction, then it is reviewed by legal. But for the most part, we really don't know until all of the facts of the case
You listen
are
to,
reviewed,
okay.
whether it would fall under our jurisdiction or not. And if it doesn't, then those are the cases that legal presents to be dismissed.
Right.
And assuming the commission agrees, it's dismissed, closed, and both parties are sent a letter.
Right. So we are able to catch some of those complaints on the front end. So our centralized complaints division sometimes will send an email to me and Caitlin that will say, what do you recommend? Do we have jurisdiction over this? Yes or no? But we're not able to catch all of those complaints.
Okay.
So we do get some of them out that do not have jurisdiction beforehand, but others sometimes make it into the legal report. But just also, even if it's a determination that ultimately there's no infraction and it would need to be handled by an outside party, that doesn't mean that the matter would necessarily be closed initially, as there may be other real estate issues that we would need to look at the whole complaint file. So we're really looking to see if the facts and conduct fall under the statute and the rules. So that's why sometimes you'll get a few of those onto the legal report that end up not having jurisdiction and are closed.
Okay. All right. Thank you.
Other questions for Caitlin? Caitlin, I would refer you and commissioners back up to your profession count, number of licenses you guys are taking care of. And I can round that up, but it could be as many as 50,000 licenses in some form of status or another. And so before I ask you this question, Caitlin, commissioners, have you been getting any complaints about the real estate commission lately? And I promise you, that's a marked change from years past. And it has to speak to what a great job Caitlin and her staff are doing under tough circumstances, not even working at the office, to keep this regulatory body working smoothly. And so, Caitlin, I hope you'll keep telling your staff that I keep bragging on them, because it's so nice not to get people calling me 3 or 4 times a week complaining about something, how long it takes to get licensed, how ineffective the staff is. We've got a great staff thanks to you. Now,
Thank you.
Do you want to mention errors and omissions insurance just so everybody's aware?
Yes. What I was going to say, if somebody is reaching out to you, it's a 75 to 85% chance that their license is expired over a year. Those are the biggest complaints that we get. But yes, errors and omissions insurance, about 80-ish% of our licensees all expire at the beginning of the year. So January 1st, 2021, we have renewed the contract through an RFP process with Rice Insurance, and those renewals are now open. All renewal notices have gone out. I believe they went out at the end of October. So we are just beginning the thick of renewal time. And anybody that does not renew their E&O insurance will be suspended. We typically give a few-week grace period just because of the holidays with Rice getting us feeds that came in over the holiday. But at the end of January, the numbers go significantly up, and you'll also see our complaint numbers go up as a result of failure to maintain E&O.
Joe.
Caitlin, on your open and closed complaint report, just looking at a year ago or so, the sanctions were significantly higher than they are now. Is that because we're not putting out sanctions,
No,
or
that's
what is that
E&O.
exactly?
That is E&O.
Okay.
All principal brokers have a responsibility to ensure anyone affiliated with their firm maintains E&O at all times. And if a principal broker has an affiliate or broker licensee with their firm that fails to maintain E&O, that results in an automatic sanction. So what you're seeing there in those numbers are people that have failed to maintain E&O for over 6 months or more.
So you've done a really good job of from 5/1/19 to 5/1/20. The next 3 months or so. There was, just off the top of my head, 100 of them in that 5-month period, and now you've got it down to probably 30 or so. So y'all are doing a good job communicating or something.
Well, thank you. But yeah, I think we will see that happen again with each renewal cycle. So.
And by the way, like January, February, March, April, May of next year, many of you commissioners may get calls about sanctions related to E&O insurance that was failed to be purchased. And I think Ann and Caitlin would both agree that those calls should be sent to E. Ross White. No, just kidding. Should go to, who gets those calls, Caitlin?
They can just call our main line. We have, over 6 people that answer the phone at all times. So they can go there. If they have a question about where to send their policy, it can go to TREC.eo2. If you get our newsletter that went out today that has additional information on E&O, but if they want to send their policy in, there's a specific email that all E&O policies go to. And we're making a big push this year for firms that are not on Rice insurance policy to still send their E&O via a feed, which is essentially a spreadsheet. We've gotten our system down where all of those get uploaded at once and automatically get added to each licensee's account. But of course, refer any questions to me.
Thank you,
John.
Yes,
John, we'll need to get Mr. White's direct number for that.
All right, Steve.
One last question, Caitlin. On this report, if I look at October, it says closed cases 51. Does that relate to September, or does that relate to, I'm wondering, when you close a case, you don't close it until we meet, correct? Or not correct? Or is it a combination?
It really doesn't get closed. It really does not get closed until the person has agreed to the order or the case has been dismissed. So
okay,
it doesn't get closed until you guys it's been presented to you, you've agreed to the discipline, and they've signed and executed the consent order. Or, those also reflect cases that are dismissed, but it really doesn't necessarily reflect any particular month. Some of those that you see that are higher are a result of our E&O complaints and the influx with that, but otherwise it's constantly a rotating of opening and closing, cases getting dismissed and cases getting closed because the respondent has agreed to said discipline.
So, okay. I guess if you added up both of those columns, it wouldn't necessarily be 363 difference, correct?
No.
Okay.
Questions or comments for Caitlin before we move to the legal report? All right. Thank you, Caitlin. I sort of asked Caitlin at one point to maybe have Aaron prep to call the roll on votes. Are you going to do those all, Caitlin, or are you going to delegate some of that?
I'm going to do them unless my internet goes out, and then I've got Aaron on standby.
Perfect. Okay, Shalina.
Yes, good morning, commission members.
Good morning. So we've got a boatload of cases, and the most difficult part might be reading into the record 88 case numbers.
Yeah.
Is that your first assignment, Shalene, or can we pass that off to say, no, we can't? Go ahead. If you'll get started. I was thinking Ross might be a good person, but maybe not.
Sure.
So, are you prepared to do that?
Yes, I am.
All right, Commissioner, stand by.
Okay, so first let me make a correction on the consent agenda. Number 7 and number 8 had the same complaint number. So number 7 will be corrected to reflect the proper complaint number. So beginning with number 1, 2020048861. Number 2, 2020048311. Number 3, 2020049361. Number 4, 2020050991. Number 5, 2020051531. Number 6, 2020051851. Number 7 is corrected to 2020065771. Number 8 is 2020051881. Number 9 is 2020052901. Number 10, 2020053771. Number 11, 2020055081. Number 12, 2020045921. Number 13, 2020048441. Number 14, 2020051991. Number 15, 2020054301. Number 16, 2020050331. Number 17, 2020048091. Number 18, 202000051541. Number 19, 2020051771. Number 20, 2020052721. Number 21, 2020053321. Number 22, 2020053921. Number 23, 2020055251. Number 24, 2020055411. Number 25, 2020056331. Number 26, 2020042881. Number 27, 2020046741. Number 28, 2020045701. Number 30, 2020060701. Number 31, 2020065061. Number 32, 2020047291. Number 33, 2020051821. Number 34, 2020050961. Number 35, 2020055641. Number 36, 2020049931. Number 37, 2020052871. Number 38, 2020054101. number 39, 2020055-271, number 40, 2020056-481, number 41, 2020056-601, number 42, 2020057-641, number 43, 2020058-161, number 44, 2020058-171, 45, 2020051-761, 46, 2020055-471, number 47, 2020050-261, number 48, 2020051-311, number 49, 2020054-331, number 50, 2020054-351, number 51, 2020055-731, 52, 2020056-401, 53, 2020057-241, 54, 2020057-821, 55, 2020058-701, 56, 2020058-741, 57, 2020058-921, 58, 2020059-571, 59, 20200600001, number 60, 2020052, 2020005, sorry, let me correct that again. 2020052-531, 61, 2020053-461, 62, 2020060-551, 63, 2020051-521, 64, 2020058-751, 65, 2020060-291, number 66, 2020058-451, 67, 2020061, 391, 68, 2020062, 111, 69, 2020054, 851, 70, 2020057, 811, 71, 2020061, 711, number 72, 2020057, 701, 73, 2020057, 161, 74, 2020062, I'm sorry, 74, 2020065, 471, 75, 2020066, 241, 76, 2020064, 941, 77, 2020069, 131, 78, 2020063, 351, 79, 2020061, 541. The cases to be represented, number 80, 2020006, sorry, number 80, 2020039-331, 81, 2020002, 981, 82, 2019-031421, 83, 2018-014, 1551, number 84, 2020041-031, 85, 2020041-051, 86, 2016-071-791, number 87, 2018-038-221, and number 88 is 2017-077-801.
Thank you, Shelley. Caitlin, a quick question for you. Did you send this list of cases to be pulled to everyone or just to me?
I sent them to you and to legal.
Okay, so this one was, I thought you might have done one of those blind carbon copy deals you were talking about earlier, and I just couldn't tell. All right, commissioners, 88 cases. Here's the good news. Only 27 of those cases are to be pulled, which means that in a moment, I'm going to look for a motion to approve council's recommendation on 61 of the cases. But in the meantime, if you're keeping track, here are the cases that commissioners have asked to be pulled. So you may want to make a list. 5, 8, 9, and 11, 17, 21, 24, and 26, 32, 42, 45, and 46, 50, 54, 55, 57, 58, 60, 63, and 72, 75, 78, 79, and 80, and 81, 82, and 88. Now, are there commissioners who would like additional cases pulled? The chair would love to entertain a motion to accept council's recommendation on cases read into the record a moment ago, with the exception of the cases I just read into the record. DJ Ferris making a motion to accept council's recommendation, and John Moffett seconded it. Discussion. Celine, are you okay with the motion without me reading it back in again?
Yes.
Okay. All right. We're ready to vote. If you're in favor of approving council's recommendation on 61 of the cases in today's legal report, you'll vote aye when your name is called. If you're opposed, you'll vote no. Caitlin.
Joe Begley.
Aye.
Jeff Diaz.
Aye.
DJ Ferris.
Aye.
Marcia Frank.
Aye.
Steve Glenn.
Aye.
John Moffett.
Aye.
Joan Smith.
Aye.
Stacy Torbett.
Aye.
John Grease.
Yes. All right, that motion passes. And just if it makes any commissioners feel better, there was a time when every one of these cases would have to be read in the record individually and then voted on individually. So this is a much better circumstance. But we just have a lot of cases to handle today, and commissioners who have questions and concerns about particular cases, including myself. We're going first to case 5. DJ, let's talk about your concern on that.
Yeah, I'm pulling it up now. This was about the what caught my attention was the just a reminder, really, for licensees to have disclosures sent out and confirm they were received and signed prior to an offer being written. I think we would agree that's the best protocol, and I just wanted to suggest that be sent out to this respondent.
Do you like a letter of instruction sent to her or him?
I think that would be fine, yes.
Would you like to make that?
Yeah, I'm sorry. I'm trying to pull this up so I could get it. Yeah, I moved that we send a letter of instruction to this respondent.
Is there a second? Jeff Diaz seconds the motion. Is there discussion? I hear none. Let's call the roll. Caitlin, if you're in favor of sending a letter of instruction to this licensee, you'll vote yes. This respondent, you'll vote yes. If you're opposed, you vote no.
Begley. Joe Begley.
Aye.
Jeff Diaz.
Aye.
DJ Ferris.
Aye.
Marcia Frank.
Aye.
Steve Gwynn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Reese.
Yes. All right, that motion passes. Number 8, both DJ and myself flagged number 8. And DJ, you're going to get the floor in just a second, but please look at, commissioners, look at council's recommendation as we talk about it. DJ.
All right. I made note of it, and Shalina has made pointed out that it's the same one as 7 and 8. That's the reason I flagged it. It looked like it was the exact same one. That's where it caught my attention.
So
There
here's what
were
caught my
2
attention.
complaints. Yeah.
Go ahead.
There were 2 complaints filed against the same respondent that were identical and given 2 different complaint numbers. So one of them is being closed, and the other one is being recommended that action be taken. But they're identical complaints.
Okay, so we're talking about number 8. Council's recommendation is a $4,000 civil penalty. And I don't disagree with the recommendation. However, we've got a principal broker who won't give money back to a property owner, and the principal broker is managing 2 properties, not just one. And the principal broker refuses to give the money back on either of those properties. So, Shalina, my question to you is, if commission was inclined, could they double your recommendation and still be okay?
Yes, most definitely. It's at the discretion of the commission to assess the civil penalty.
All right, commissioners, discussion. Marcia?
I think this person obviously, they just came on the brink of disaster to me as a principal broker. So out of the kindness of our hearts, I think that we at least need to make sure that they take the principal broker core class, because I was really on the verge of downgrading their license. So they at least need to take the principal broker core class and not use that as CE credit.
Is that in addition to council's recommendation?
I would like to add that to council's recommendation and along with the $8,000 recommendation.
Okay, Joe.
I was a little confused on it because at the end of the first paragraph, it says the respondent did not return the security deposits. And then it says respondent sent checks payable to the tenants. And then down below, it's like they haven't left yet. And the lease says the respondent provided a response to say the security deposit will be returned to the tenant when the property has been vacated, and these checks were written in the tenant's name. I can't tell if checks have been written or haven't been written or made out to the wrong person. I'm just confused on.
Yes, let me clarify that. What happened was the checks were written in the tenant's name and sent back to the complainant instead of being written to the complainant in the complainant's name. So although the checks were sent, they were made payable to the tenants, which was not correct.
So is that why we're penalizing this guy? Because his assistant or somebody wrote a check to the wrong person and sent it to him? Or I don't understand. I mean, if that's a clerical error, or if the lease says, the checks are being made to the tenants. I mean, I don't understand exactly what he did here. Did he refuse to return money, or is he just returned it to the wrong? Did he just make the check payable to the wrong person? Because
No, this was It was intentional on the part of the respondent. The respondent at first refused to return any monies and then finally did send the monies, but sent the monies in the name of the tenant's name instead of to the property owner's name. So they can't be deposited into any account and be held as security deposit.
Joe? You okay, Joe?
Yes, thank you.
Okay. Okay, so Steve.
Well, I'm confused now because it was the intent when they issued the checks to what was why did they was it a screw up or what was the because the tenants were the ones that had put the money up under the terms of the lease, right?
Right. This was intentional. The respondent was supposed. Yes, he was
Okay, it
supposed
was
to
intentional.
return. Yes.
All right. The second question then is, how did you come up with 4,000? Just out of curiosity.
For each of the violations.
2,000 per?
No. Look at.
No, 1,000 per violation.
Ah.
On 2 properties, though.
So let's get back to what's in front of us. The chair's going to consider. I'll be right to you, Joe. But the chair believes that a motion was made by Commissioner Franks that, if I can get a second to, would offer a civil penalty of $8,000 plus require the principal broker to take the principal broker's core class within 180 days and not allow that course to count as credit toward continuing education. So I'd like to see if there's a second before we get too much further. Jeff Diaz seconds the motion. Joe Bagley, you got the floor.
I'm as a broker. If I was managing, I mean, help me out here. On a lease with you, John, and I'm to hold that money. The lease says that when the tenant leaves, that, you know, if it's clean and all that kind of stuff and not damaged, that you're going to get the money. The tenant's going to get the money back for the security deposit. So I have an owner that may be difficult. The money is in my trust, my escrow account. So if this lease is not expired and I take the money from my trust account and give it to this other person, and then the lease expires, the tenant moves out, it's in perfect condition, and he says, "Hey, where's my check?" And I said, "Call the owner." And the owner says, "Tough luck, buddy." So then they're like, "You had my money in escrow." So I don't know. Is there not a weird situation there where they've changed management companies and that broker's still kind of responsible for those leases and that escrow money? Or should he release it back to the owner of the building? You understand what I'm saying?
Well, I'm pretty sure that the original management agreement signed between the owner and the first broker probably stated, maybe Shalina can confirm this, that at the time the agreement is terminated, any funds in possession of the principal broker be turned over to the owner. If I'm the principal broker and I'm not managing anymore, I don't want any more liability for anything going forward. So, Shalina.
Yes, that would be correct, because this was transferred to a new property management firm, and that owner of the property would deposit the monies with the new property management firm, meaning the security deposit would be held by that firm.
For old leases, new leases, or just the new leases?
For whatever property that was being managed, those funds should have been turned over to the owner to transfer then to the property management firm, the new property management firm.
I guess my question, what paperwork did the broker need to release the funds? Where is that the new property managers got some paperwork that says I'm going to now be holding these in escrow, and you get the tenant to sign it that it's been moved? When you leave money, when money leaves escrow, you need a paper trail, and I just don't. Sending them back to the owner doesn't help sending them to the new management company. I just think $8,000, and I'm just not clear enough on the whole thing until.
Yeah, I'm really not either.
The money's leaving my escrow, and I need some paper trail.
Well, the complainant is the owner and filed the complaint, but the new property management firm was attempting to obtain all the documents, records, and monies. And in the interim, this owner had to intervene in order to get those monies transferred to the new property management firm, which would then execute the necessary documents with the tenants.
And Joe, let me say one more thing. To write a check to the tenant and send it to the owner is a joke. What if the tenant trashes the place on the way out? I mean, how is the owner going to be made whole except for that security deposit?
Oh, I understand that part. I'm just saying that I may want to hold it till those people left, and then, on those two particular leases, you can have all the paperwork, you can have the leases, you can have everything, but once they expire, because I've got to answer to the tenant. What if the owner just takes the money and spends it?
Well, I would guess, Shalina, the leases were between the owner and the tenants, not the broker holding escrow funds. So if the tenant has a problem, it's with the owner, not with you. Hopefully. But in any case, that's why I pulled it.
Let's vote.
You ready to vote?
Well, can Selena tell us if that is the case, if she has that lease and the wording on the lease?
I will have to look that up and see if we have that lease in the file.
Yeah, Commissioner Ferris here. 8,000 does seem a little high, but I'm not against some type of disciplinary action.
So DJ, two things. First of all, if you'd like to make a substitute motion, I'd be happy to entertain it. And second of all, if it does pass as it's been stated, and the releasing principal broker doesn't like it, he doesn't have to agree to it, or she doesn't have to agree to it. It would just go to a formal hearing where we get more details. So I'll give you the first choice. If you have something you're more comfortable with as far as a motion, I'm happy to see if we can get that on the floor.
I'm not quite ready there yet. I got a question. This last statement, the last sentence says the respondent is willing to reissue the checks, but has not received the previous checks in the tenant's name previously sent to the complainant. So Commissioner Begley's point, was this a clerical issue problem? I don't think it was. I think they just wrote it. That's number one. Is it a clerical problem? Which I don't think that was the case. Number two, did he just do this and wasn't thinking? Like to your point, Chairman Grease, it's he just sent it with the tenant's name, not thinking about how the complainant or the owner might have any recourse to be made whole. And so if he just wasn't thinking correctly, that's where my thoughts are. If 8,000, he'd never do it again, probably, if he got charged 8,000, seems like, for this. But at any rate, those are my thoughts on that. I'd love to hear more thoughts from the commissioners.
So maybe his thought process was, I'm going to send it back to you to give to the tenant. You get a new security deposit from your new management company in their escrow account. So I'm going to hand John a check for $500, and he's going to hand me a check back to the new company for $500, and I'm out of the deal. But if I give it to the complainant, and the tenant comes and says, "Where's my money?" and I say, "I don't know," and then they call the guy in California, and his numbers changed, and it's like, "You have my money. It says on that lease you're going to hold my money." So, I mean, I'm just not clear enough in the whole thing to do $8,000.
I would say this, that's why we need to see what does the paperwork say, because whatever the paperwork says will answer this question for all of us.
This respondent was willing to reissue the checks after this complaint was filed. So in response to the filing of the complaint was when they were going to reissue the checks in the owner or the complainant's name.
What does the agreement between this principal broker and the owner say?
I have to look that up. If you'd like to give me a few minutes to do that.
Well, I don't think we can rule on this until we know what the contract says.
What if you say, let's take about an 8-minute break, and we'll come back to this.
Okay, that's a good idea.
All right, back at say 5 minutes after.
Okay.
When we last left, we'd asked Shalina to look at the document and tell us what the agreement stated related to regarding the owner and his first property manager. Shalina, what did you find?
Okay, so the agreement, the lease agreement was between the property manager and the tenants, and it called for the monies to be held by the property manager. However, the agreement between the owner and the property manager requires that all books, records, and monies being held be returned to the owner upon termination of that contract.
So it's pretty clear cut.
Yes.
Okay, so just to reiterate, at the moment, we have a motion on the floor suggesting an $8,000 civil penalty and a principal broker's core class within 180 days. Jeff?
I just wanted to be sure. So in the agreement between the property manager and tenant, there's no language in there that talks about disbursement of going back to the tenant.
I'm sorry, could you repeat that?
I just want to make sure the two contracts aren't in conflict. So the contract between the property manager and the tenant is silent about any returns of security deposits.
It says that until the tenancy is concluded, the monies will be held by the property manager.
Okay, so the contract between the first property manager and the owner rules here.
Yes, because that terminated, that agreement for them to provide property management services terminated, and therefore those monies and the books and records and any other information related to the tenancies should have been transferred back to the owner.
Okay. Thank you, Selena.
Okay, so now if there's a substitute motion someone would like to make, it's a good time to do it, or we can vote on the motion, and if it fails, then I'll take another motion.
Mr. Chairman.
1 second, Marcia.
I just have one more question for Shalana. Why in this does it say the checks that were originally sent are non-negotiable? Why is that? What do you mean by that?
The owner, there was nothing the owner could do with those checks. They were non-negotiable to the owner, to the complainant.
They weren't hot check. I mean, they were just written to the wrong party, correct? Okay.
Marcia.
Yes, and I wanted to help the other commissioners with my thinking about the 2,000 per case. I think it's pretty important that we try to, as much as possible, to be consistent with our rulings. And this is consistent with what we've done in the past. And so that's why I also am holding the principal broker to a higher standard than I would anyone else, because the principal broker should have known better than this. As I said, I almost wanted to ask for the license to be downgraded because I feel like this is egregious. So that's why my reasoning for the $8,000, DJ.
Thank you, Marcia. Jeff.
So Marcia, should it have been appropriate for that broker then to write one check payable to the owner? Is that what it should have happened?
Yes, because that's what the agreement says. So that principal broker should have written a check to the owner and did not. They circumvented the owner by putting someone else's name on it. I'm worried about those funds because they still haven't gone to the right person.
Thank you. Chairman, I call the question.
Okay, so we're going to vote on the motion on the floor. If you're in favor of offering this principal broker an $8,000 civil penalty and require him or her to take a principal broker's court class within 180 days, you'll vote yes. If, on the other hand, you're opposed, you'll vote no. Caitlin?
Joe Begley?
No.
Jeff Diaz?
Aye.
DJ Ferris?
No.
Marcia Frank?
Aye.
Steve Gwynn?
Aye.
John Moffett?
Aye.
Joan Smith?
Aye.
Stacy Torbett?
No.
John Grease?
Yes. Okay, in the opinion of the chair, that motion passed on a 7-aye, 2-no vote. So what you had, Caitlin?
I have 6 ayes, 3 noes.
That's what I meant to
I've
say,
got
6 ayes and 3 noes. My fault. High school education. All right, next up is number 9, DJ.
Number 9, my question is, thinking back on October's meeting and maybe even our September meeting, how do we know there was just one instance? And contrary to how I just voted for the previous complaint, how do we know this person doesn't have multiple instances where it would be warranted to authorize more than $1,000 for the civil penalty? Because they may just see this as a cost of doing business and pay it and not even tap the brakes.
Yes, that's very possible. Unfortunately, we have to go by the complaint that's received and that information. We really don't know what type of unlicensed activity or the extent of that unlicensed activity this individual is involved in. So although there might be much more going on, we don't have that information.
Okay, thank you.
So DJ, based on that, are you ready to make a motion to accept council's recommendation?
Any other commissioners have any other thoughts? If not, I do have, Chairman, yes, I would make that motion to accept council's recommendation.
Jeff Diaz seconds the motion. Discussion. If you're in favor of the motion, vote aye when your name is called. Caitlin?
Joe Begley, Jeff Diaz,
Aye.
DJ Ferris,
Aye. Aye.
So Caitlin, you've muted yourself.
okay. I'm gonna do a couple of these over again. Marcia Frank,
You're muted, Marcia.
I see a verbal aye. Steve Gwen,
Aye.
Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grief.
Yes. Okay, the motion passes. Number 11, Marcia, let's let you speak to this.
On number 11, there seems to be a controversy over whether this is as is on the contract. So I'm looking to see what the property disclosure says and is as is written on the contract. And especially since some repairs were completed.
Yes, it was written as is in the contract.
Okay. Do you think, Shalina, maybe this was a property disclosure problem, not a problem with the broker?
Correct.
Okay. I move that we take council's recommendation to close.
Jeff Diaz seconds. So DJ, you'd also pull this. Other thoughts?
I don't believe I'd pulled that one. Number 11.
Okay, my fault. Caitlin, let's vote. If you're in favor of the motion to accept council's recommendation, please vote aye.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Frank,
Aye.
Steve Gwen,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grief.
Yes. The motion passes. We go to number 17. DJ, I've got your name on this one.
Reviewing that again now, and on the one hand, I'm in agreement with the recommendation by the council, but I had a question because as I read this, it reads as the parties not able to reach an agreement. And so it sounds like there was no written agreement. And maybe that explains why the respondent was not acknowledging these requests for release by the complainant. I don't know that. But then when the respondent provides a response and states the issue was resolved between the parties, the buyer and seller agreed to split the earnest money. So that means to tell me that some type of an agreement was reached. I guess there's some holes in the file here, but that was my question about it. The respondent's sake, there was not a written agreement, and there was an offer, counter offer, and there never was a binding agreement, then maybe the respondent thought that that there wasn't any reason to respond. There wasn't any deal. But I guess as I'm thinking about this more, there obviously was some sort of deal. If buyer and seller agreed to split the earnest money, then the $1,000, yeah, at least that much for being diligently responsible. So. Yeah.
Yes, the parties did reach an agreement, and there was a contract that was bound. However, it fell through for whatever reason, and then the seller's agent was non-responsive on multiple occasions. And although they resolved the issues, in my opinion, because they failed to respond on so many times to release the complainant, that's why my recommendation is to open a contested case and assess a penalty.
I'm confused on this one too. What was the complainant requesting a release from? A release? What did you mean by that? A release from a contract? Because there was no contract, the way I'm reading it.
There was a contract. I apologize. That should be included in there.
It says the parties were not able to reach an agreement as of June the 5th. So I assumed as of that date, there's no deal, there's nothing to release from. But then it said, so does that mean there was a contract after June the 5th?
No, there was a contract after June 3rd, and then there was a dispute, and they didn't.
Well, I mean, it's a counter offer on June the 3rd. It doesn't say that there was a contract. I mean, an offer, you have to have acceptance before you have a deal, and it doesn't say that there was acceptance, that at least I'm reading it.
There was a bound contract, yes.
As of when?
June the 3rd.
June the.
Okay, so the way this ought to have been written, then maybe the seller counteroffered on June 3rd, 2020. The buyer accepted that term. The buyer accepted that offer, and a contract was reached. Period. I don't know.
What about that second sentence that says the parties were not able to reach an agreement as of June the 5th? What does that mean?
There was an issue, I believe. I have to look at the file, the details, but they were not able to reach an agreement. And dispute arose.
But
how can you have a dispute if you have no contract?
A dispute arose following the binding of the contract.
What was the dispute? Do you know that?
I'd have to check.
Because after it's bound, it's bound. Unless there was in the contract that enabled the seller, the complainant, to get out of it, and then they would need to ask for a release. That's only 2 days, though.
Yes, and I believe that's why ultimately they split the earnest monies.
Wow, this is.
So is the issue that at some point there was a contract, the deal fell through, the buyer asked for his deposit back, and the agent was slow delivering it?
Yes.
That's what we have in front of us. DJ.
Sorry to interrupt, Chairman.
Go ahead.
Somebody on the commission or in staff, correct me if I'm wrong, as I see it in my practice, what is the ruling? Like, is it 21 days or 28 days that earnest money has to be released once it has been requested or agreed upon release? Is there I feel like my broker came up in my business last year where we were talking about the timeliness in which a firm is required by statute to release earnest money. And we were talking about that because title companies aren't under that statute. They can hold earnest money indefinitely. A real estate firm can only hold it for such and such time, 21 days, I think, or maybe 28 days. And while I do agree, it looks like the respondent should have been more responsive. I want to confirm that there's not a real date out there that the respondent was within before this could be resolved.
Okay, let me clarify this. This might help. I just checked, and it appears that the bank was unable to process the approval of the loan due to COVID, and that's what led to the contract falling through, and the parties were unable to proceed with the transaction. So maybe that will clarify the issue here.
So the bank only gave it 2 days?
I believe during the process of all of this happening was when the bank said that they could not approve this financing for the buyer.
Okay, commissioners, this is, if you're uncomfortable with recommendation of council won't take it personally. We just need to get a motion on the floor so we can continue discussion or to vote. So, DJ, you were about to make a motion. You may want to change it at this point, or you may want to go ahead with it.
Dude, I may be ready to make. Okay, I'm just looking at Anna. Let's see here. Anna sent me the link here for 21 calendar days. Okay. Yeah, I moved to accept council's recommendation.
Accept council's recommendation. Is there a second? Joe, change this second motion. Now, I only have one comment. Shalini?
Yes.
The complaint is not against the principal broker who held the money, right?
I'm sorry, can you repeat that?
The complaint is not against the principal broker. Correct.
Correct.
Shouldn't it be against the principal broker if it has to do with release of deposits?
I'm not sure.
I don't think anybody but the principal broker has the right to be able to release money.
Well, this is listed as a real estate broker in our core system. Caitlin, does that mean that this is the principal broker?
Let me double check. It might take just a minute since I have to figure out who the person is. Do you guys want to go on to the next one and I'll do the research for you?
Let's do it. We'll keep number 17 on abeyance and go to 21. Nope. No, I'm sorry. Is that right? Yeah, going to 21.
Yes, that's right.
Okay. DJ and I both pulled this out. Here's my question. Shalina, this looks to me like a complaint, like an in-house complaint between two licensees in the same firm. Is that your sense?
Yes.
Well, we don't we very often, not very often at all, handle complaints to agents in the same firm. And in this case, I'd like to hear from the principal broker. That's who ought to be making this decision, not us. And so I would be in the mood to ask this case to be deferred for 30 days and see if you can get the principal broker to give us his or her take on what happened.
Okay.
Is a motion
I'll second that.
You made the motion, Marcia. Who'll second it? Jeff Diaz seconds
Are
the
you
motion.
wanting to open a complaint against the principal broker, or are you just wanting a response?
I don't want to open a complaint at this point, but I might at some point if he says, I don't know anything about it, then to me that's failure to supervise, and we might have a complaint at that point. But right now, this is an in-house squabble, and the principal broker should have handled this. It shouldn't have gotten to us, in my opinion. So I'd like to know that broker's comments. So the motion on the floor, made by Ms. Franks, seconded by Mr. Diaz, is to defer for 30 days so we gather more information. Is there more discussion? DJ, I'm sorry, you also pulled this one. Did you want to talk about it? You're good.
I'm good.
Okay, let's vote. Caitlin, if you're in favor, vote aye. If you're opposed, vote no.
Joe Begley.
Aye.
Jeff Diaz. DJ Ferris.
Aye.
Marcia Franks.
Aye.
Steve Gwynn.
Aye.
John Moffett.
Aye.
Joan Smith.
Aye.
Stacy Torbett.
Aye.
3.
Yes. All right, that motion passes. Number 24.
If you'd like, Chairman, we can go back to number 17. We've checked, and it is a principal broker.
Okay, perfect. So,
I'm actually only showing it as a broker. We might.
Oh.
Let me do a little bit more digging. Who is showing it as a principal broker?
Carol, are you on the line? You said it was a principal broker.
I'll get with Carol. I'll get with Carol via Jabber.
Okay, she said it was a post-broker education was completed.
Yes, no, yeah, that just means that they completed their 120 hours.
Yeah.
But to me, it appears that they're just a broker.
Still muted, John. John, you're still muted.
You're muted, John.
So I was about to ask people on this conversation to have their mute button on unless they're speaking, and then probably appropriate that when it's time to speak, you push your mute button off. Just a thought. 24. We'll keep 17 open for a moment. Go to 24. So here we have a complaint about a broker advertising amenities, and when the buyer who bought it, perhaps sight unseen, shows up, none of the amenities are in place. And the broker's defense is, well, the developer says he's going to do it, so I thought it was okay to advertise it. Shalene, is that a pretty good summary?
Yes, I don't know if necessarily this respondent was advertising that, but they did state that there were these amenities available, and they based it on the developer's website, and that these were all being slated to be built and would be built.
Marcia.
So my husband is a developer. And we don't usually put the amenities in until the time that the Franklin city government tells us they have to go in. So there's a ratio there. It's different with the Williamson County if it's something built out in the county. So we advertise that these things are going to be built, and we show pictures and drawings of them because they are to be built. And if they're on a plat, they have to be built. So I think this is, this. I would say that it needs to be closed because the developer doesn't have to put them in until the city tells him what that timeline is.
So, Marshall, what caught my attention was the narrative says there were walking trails, lakes by pavilion, lake with pavilion, gazebo, and playground. Not that they're going to be, there are. That's the only thing that caught my attention.
Those are the easy things that go in when you're grading. So when you're doing your grading, which is the very first step of any development, those things would be laid out. The trails would be laid out. The lake is already there probably. So they maybe just decide to go in and build a gazebo, which wouldn't cost much money. And a playground is just a matter of putting some mulch out and some playground equipment. So those are very, very easy things that the developer probably went ahead and did. The big ticket item is the pool and bathrooms for a pool and parking for a pool.
So you won't hurt my feelings if you make a motion to accept council's recommendation.
I would make a motion that we accept council's recommendation.
Is there a second? Jeffrey seconds the motion. Discussion. Those in favor of the motion will vote aye when their name is called.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Frank,
Aye.
Steve Glenn,
Aye.
John Moffitt,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Green.
Yes. So that motion passes unanimously. Next up is number 26. Marcia, you want to speak to this first, and then DJ?
I didn't have that number 26.
DJ?
Yeah, I just didn't understand this one at all. It sounds like the respondent is engaged in fraudulent activity, but also sounds like the complainant needs to have better guidance on what they're doing. Could you explain this to me?
Sure. This was an offer to the complainant to purchase their timeshare located in Mexico. And there obviously is some fraud involved here. And unfortunately, the complainant did enter into an agreement for the respondent to purchase this and sent them money, wire transferred them money, and never heard back from the respondent, who is an unlicensed real estate firm. And that is the charge, not necessarily the fraud, but the fact that they're an unlicensed real estate firm. And this real estate firm, their main office address is located in Tennessee, and therefore the complaint was filed with the commission.
Thanks.
Lena, in association with this firm, is there an individual person named in the complaint as well?
No, the firm is the only one named in the complaint.
Can we make it $2,000 since there's 2 wire transfers?
Well, this is just, this is an unlicensed firm, so the civil penalty is we would have to determine how many days they were unlicensed here. But at this point, I would leave it at $1,000 for unlicensed activity.
The problem with ones like this, it just really gets under my skin because $1,000, and I agree with Selena that that's our only penalty that we can give them. But that $1,000 is probably just the cost of doing business to these people. I mean, this could be one of those things that even though there's very little done about it, it may emphasize the matter to them if we turn it over to the DA's office, wherever this office is, whatever city that is.
Shalina, was an attempt made to get a response from the firm?
Yes, and they did not respond.
Do you have a phone number and an address?
No phone number is available, but we did have the address and have sent it multiple times.
Okay, the chair will accept a motion to accept council's recommendation. Steve Gwynn makes that motion. Is there a second?
I'll second it.
John Moffett seconds the motion. Discussion. Let's vote. Caitlin.
Okay, just to confirm, I know John Moffett seconded. Who made that motion?
Steve Gwynn.
Okay. Joe Begley.
Aye.
Jeff Diaz.
Aye.
DJ Ferris.
Aye.
DJ Marcia Franks.
Aye.
Steve Glenn.
Aye.
John Moffett.
Aye.
Joan Smith. Joan Smith.
Aye.
Stacy Torbett.
Aye.
John Grease.
Yes. All right, the motion passes. Let's move. Joan.
Yes, I have a question. When you have a situation like this, when you have no way to contact them, you try, you don't have a phone number and they're not responsive, how do you ever collect anything or show that they have been penalized?
It varies. Often we do have success in locating them and properly serving them when we bring it to hearing. You just can't predict. Sometimes these businesses go defunct and you can't find anyone, and then you can't proceed with the matter. But I can't say. It just depends.
And Joan, that's why I was saying, since we have an address, it could be turned over to the district attorney's office. That's why I suggested that.
Okay, thank you. Thank you.
Okay. Number 32. This is for educational purposes only. So we've had a boatload of timeshare complaints this month. And in each case, Shalina has referenced a statute that refers to 4 years. And some of you may have heard me in the past talk about 2 years. So to Shalina's credit, she has corresponded back and forth with me. I might have stretched her patience, but she's been very helpful about this. She's explained to me by email that the reason she quotes the 4-year period is so that a complainant who can't get any relief from the Real Estate Commission still may have a window to file a civil suit in some court. And for instance, in this case, the complaint the complainant purchased a timeshare in June of 2018. Her recommendation is to dismiss because the title company had all the paperwork, all I's dotted and T's crossed, and the rescission period had expired. And yet it still mentions a 4-year period. If I'm stating this correctly, Shalana, the reason you do that is to let the complainant know they may have other resources besides Real Estate Commission.
Yes, and also to let the commission know that there is a private right of action by, a party to bring a civil lawsuit in order to be made whole, because, certainly if there was an action the commission could take, they would, but in this case, they can't, but there still might be some other recourse for the complainant.
So, with that said, this case should be closed per council's recommendation. Who would make that motion? Jeff Diaz makes a motion, a second by Joan Smith. Discussion. Let's vote. Caitlin.
Joe Begley,
Yes.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Frank,
Aye.
Steve Gwynn,
Aye.
John Moffett,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Caitlin, you're muted.
Stacy Torbett,
Aye.
John Grease.
Yes. That motion passes. Let's go to number 42. Marcia.
Yes, this is the one that the earnest money was not returned because some wiring had not been done. And I'm just wondering, did the contract say that the earnest money would not be refunded unless they got the wire up off the floor?
I believe that was one of the terms of the contract, was that was to be done, and it was not. The complainant was not entitled to the earnest money in this situation, but they demanded that it be paid to them, and that was the dispute. And they refused to sign that release as a result.
So the complainant is owner of the home, correct?
Yes.
Okay, and so there was a obviously a contract was $1,000 earnest money deposit, right?
Yes.
Okay, and so did the house close or did it not close?
It did not close. The buyer wanted to cancel the contract because of the wires. The electrical wires were not removed, and they were still laying on the ground.
Okay, so the buyer wanted to cancel the contract because of that electrical wiring, correct?
Correct.
Okay, and so the seller was not willing to sign the release, and so did the real estate broker, the principal broker, decide to make that decision when they couldn't decide?
I don't believe so. We never received a response from the principal broker in this case.
You did receive a response from the affiliate, though, right?
Correct.
So I guess I'm wondering, it should have been with the problem should have been against the principal broker and not this affiliate broker, right? If they had a claim at all.
Yes, if possibly a complaint needs to be opened against the principal broker.
Okay, so the buyer did get their money back though. Their artist money.
I'm not sure about that. I don't know. I have to check.
So, Marcia.
Yes.
I'm not trying to hurry us along, but what do you think about a motion to dismiss this case and open up one against the principal broker?
I think that's probably a good thing to do, John.
So I think there are two motions.
So that will be my motion, that we accept council's recommendation to close this and open a complaint against the principal broker.
Which Jeff, yes, just seconded. Discussion. Let's vote. Caitlin.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
CJ Harris,
Aye.
Marcia Frank,
Aye.
Steve Gwynn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grief.
Yes. Motion passes. Number 45, Marcia.
Yes, this was the one, the billboard that had the curse words on front of a child's of color's face. I don't like any of those. I don't like any of those things. So this is opened against a firm, and the firm's response was that it was a disgruntled agent and that there was nothing wrong with the ad. So I'm trying to, we're talking a billboard here with a child's face that has curse words over the mouth of this child. Okay. Maybe this is just an ethics problem and it's not in our purview. But I don't like the idea of just doing nothing about this one. It's so distasteful to me. And I will say that at tomorrow's National Association of Realtors meeting, they're going to take a vote on stuff like this, where realtors can be found guilty of ethical complaints about it. So since we don't deal in ethical complaints, I'm wondering, could this complaint be sent to the board of wherever this took place?
Caitlin, are you familiar with that?
Whether it can be referred to the association, is that the question?
Yes. Because it's not a little thing. This is a big.
Refer this to the association. A lot of times when we get a complaint, the association also gets it. There's a couple associations currently reaching out to me on complaints that were filed with both us and the association. I can certainly reach out to the association if legal doesn't have a problem with that.
Yes, I guess we could. Sorry.
I would appreciate that. I'm willing to take council's recommendation to close. That would be my motion. But in addition to it, that our executive director reach out to that board where that person is licensed.
Is there a second? Thank you, Steve. Okay, the motion's on the floor.
I've got a question too.
Okay, let me just repeat the motion. The motion is to accept council's recommendation and ask staff to reach out to the appropriate realtor jurisdiction, if there is one, and forward this on. Steve.
Did council see a picture of the billboard?
Yes, that was the other issue why I recommended that the matter be closed, is because there was no, I didn't have a visual, I didn't have any photograph of the billboard to see actually what was going on. So without that, it was difficult to make a determination if there was any violation, but based on what the complainant set forth in the complaint, there was not a violation.
So we don't really know. If you didn't see evidence of the billboard, then were you just taking the complainant's word for it, or how did that work?
Well, the respondent didn't provide the billboard either, a photograph of it either, so I had nothing to go with, and I had no evidence of any violation.
But the respondent didn't deny it, Steve. It said that they had the right to do it.
Well, it's curious to me that no one has a picture of what we're talking about. But I mean, if I was the complainant, I would have taken a picture of it and sent it into the board so we can all see what it said. I mean, I don't know if you have a realtor logo on it. I mean, did it have their name? Did it have the licensee's name on there? I mean, I don't know what was on there. It could be worse than what we're even thinking. I don't know.
Well, the complainant is not a realtor, so they don't know what the rules and laws are either. So they just filed this complaint, not knowing the proper procedures of doing it.
So, Steve, council has no choice but to recommend dismissal when there's not evidence. Now, you, as a commissioner, might ask council to go gather some evidence, and let's talk about it again next month. That's certainly a prerogative you have, if you'd like that to happen.
I think so. I mean, I'm just concerned that it's making the real estate industry look bad when a licensee, if you will, puts a billboard out there with a picture of a child with something coming out of their mouth, and it has other things on there that's, I mean, I don't know what's on there, but it concerns me that, it's making the real estate industry look bad and we're dismissing it. That's all I'm saying. So would you like council to try to get a copy of that and look at it so you can? Yeah, I think if nothing else, we write a letter, a sternly written letter that basically said this is not the way things work. If we can do that,
And Steve, maybe it needs to be the principal broker, because this they didn't know to make the charges against the principal broker. Because again, they're not a realtor. They don't know what the laws are, so they made it against the firm. Hopefully, it was the principal broker that made the response, because they did respond. So maybe it's this principal broker, in my mind, that we need to. That's who's responsible for all the advertising.
Correct.
For that company. So maybe we close it against the real estate firm, but open it against the principal broker. They're not denying that it doesn't exist, or there's anything wrong with it even.
Steve, don't you want to close it against this firm and open it against the principal broker?
Yes.
That's your motion, right?
Correct.
And I think Marcia's willing to second that, and she has. So at this point, that's the motion on the floor to discuss. DJ.
I must share that I need to recuse myself from this vote, as I believe I know the firm and I know the broker, and I will I support the conversation the commission is having, but I'm going to leave it at that.
Okay, so when the roll is called, if you'll just vote pass or abstain or recuse, will be great. Any other discussion? Any question about what the motion is? Joe?
Would it be, I don't want to put DJ on the spot, but even if he recuses himself from the vote, can he tell us a little bit if he's seen the billboard and if it's as bad as, I mean, if he doesn't want to answer that, he just has to say no comment, but I mean.
I would suggest that he not comment on this.
You got to pass, DJ.
Thank you, Joe. Let's take a vote. Caitlin?
Okay, Joe Begley. Jeff Diaz.
Aye.
DJ Ferris. Pass.
Pass.
Marcia Franks.
Yes.
Steve Gwynn.
Aye.
John Moffett.
Aye.
Joan Smith.
Aye.
Aye.
John Grease.
Yes. Okay, let's move on to 46. Marcia?
Yes, this is one where this company, they are using an ad service. And so the principal broker doesn't feel like they're responsible for it. The complaint was made against the firm. I think it's, again, one of these things that since it was made by a Tennessee resident and not a licensee, that they, and again, in this case, didn't know who to file the correct charges against. But I don't like that since they're using an advertising service. I know whenever I have any ads, if I use an advertising service, whatever, as the principal broker at my company, I still have to approve those ads. So just because there's a company that's doing it doesn't mean that takes away the principal broker's responsibility. And so for that reason, I would like to make a motion that we close this complaint and open a complaint against the principal broker involved in this case.
Is there a second? Thank you, Joe. So the motion is properly on the floor. Discussion.
The other thing I'd like to say, John, too, is that this has Nashville in it. And that's something that we don't need to know either in these legal documents.
Noted. Okay, further discussion. We're going to vote on a motion to close the complaint and open a new one against the principal broker. Let's vote. Caitlin?
Joe Begley.
Aye.
Jeff Diaz.
Aye.
DJ Ferris.
Aye.
Steve Gwynn.
Aye.
Marcia Franks.
Aye.
John Moffett.
Aye.
Joan Smith.
Aye.
Stacy Torbett.
Aye.
John Grease.
Yes. The motion passes. Number 50, Marcia.
Number 50, my question is, it looks like that this complaint was opened in August of 2020, and this person's license expired in April 2020. So I'd like to get some clarification on that.
Okay. I have to check on that. As far as the information I have is that the license is expired based on what you're telling me, but
Is there somebody that can look that up? Because I don't dare go look up anything anymore.
I'm looking it up.
Okay.
If you guys want to skip to number 54, I can look this up and get back to everyone.
Without objection, we'll move to 54. We still, which means we still have 17 and 50 open.
Well, in 17, you can go back to that licensee is not the principal broker. They are just a broker at a firm with a principal broker over them.
So the complaint should, in 17, should be against the principal broker who holds the money, not the broker listed in the complaint. Marcia.
So in that case, we don't have any kind of motion on the table, do we, at this point?
Nope.
Okay, so I would like to make no, wait a minute here. So it is against the principal broker then, this complaint, is that correct?
No.
Okay.
Didn't you say, Caitlin, this guy's got a broker, lady has a broker's license, but it's not the principal broker?
Yes, I said the licensee is licensed as a broker, but it's not the principal broker over the firm.
Okay, so it's the principal broker's responsibility to return the money, except in this case, the person wouldn't respond back at all. So I'm trying to figure out here, should they both be held culpable or just this real estate broker? So I'll make this, we'll talk about it. I'll make this motion that we accept council's recommendation and that we open a complaint against the principal broker.
Okay, let me see if I can get a second, DJ. Is there a second to Marcia's motion? Thank you, DJ. Okay, did you have a comment? Okay, my fault. I apologize. Okay, since we're ready to vote, if you're in favor of the motion that we're talking about, case 17, to accept council's recommendation. Well, council's recommendation included a civil penalty, Marcia. Your motion is to dismiss 17 and to open a complaint against the principal broker.
No, my motion is that we accept council's recommendation of a civil penalty of $1,000 for failure to diligently exercise reasonable skill and care, and that we open up a complaint against the principal broker also.
Okay. That's the motion. DJ, you seconded that. Was that your intent? All right. I've got it straight in my head. Let's vote, Caitlin. If you're in favor of the motion, vote aye. If you're opposed, vote no.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Frank,
Aye.
Steve Glenn,
No.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Green.
Yes. Okay, 50 is still open. We'll come back to it. Now to 54.
I can answer 50 if you would like.
Good.
The licensee is now active. They renewed on October 21st of 2020.
The question was, though, were they expired? They were expired when this When did they renew?
They would have been expired at the time the complaint was filed. There was, the only allowance I would say is that there was an allowance for licensees to complete their continued education late due to the executive order, but that did expire at the end of September, and licensees were not in an active status. We were just giving an allowance to complete education late.
Okay, so I'm looking for when this complaint happened. This affiliate broker was unlicensed, or were they under any kind of grace period or anything like that?
They would have been an expired grace. However, they were unlicensed if they renewed on October 21st, 2020.
So they went from, we know, at least August till October were not being licensed?
Yes.
Okay, so can I hear what some of the other members think about that?
The only thought I have, Marcia, is when this license was activated or reactivated, it was backdated to a date before this action happened, if that makes any difference at all.
So we don't have a contract or any kind of paperwork that has a date on it of when it occurred, the violation occurred, right?
I don't believe that there was any documents completed.
Okay, if there's no documents completed, then I'm just going to say I'll take council's recommendation to close.
Is there a second? Jeff Diaz seconds the motion. John Moffett thirds it. Discussion. Let's vote. Caitlin.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Franks,
Aye.
Steve Gwynn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John.
Yes. All right, the motion passes. I need to change a pace. So here's what I'd like to do. We've got a couple commissioners who can't be here for the rulemaking hearing at 2:30 today. And what I would like Anna to do, and once she's done, I'm in the mood to take about a 15-minute break so people can get something to eat, except for Joe. Anna, would you and talking to the commissioners about what they can expect tomorrow in this formal hearing?
So the formal hearing is going to be via WebEx. The opposing counsel, there's another attorney on this other side. Will be representing the respondent. I'll be representing the state, and you will get the link to the WebEx meeting is going to be forwarded to you this afternoon from Caitlin. And the hearing is going to start at 8:30 a.m. So since there aren't any, since it's going to be online, the documents will be shared with you on on the screen. So instead of physical documents.
So here's what you need to know, that Anna hadn't spoken to you yet. You can do this better than I can, Anna, but this is a formal process. So at some point, somebody can't pipe up and say, I recommend we give this person a civil penalty of $1,000.
Correct.
It doesn't work that way, Anna.
So it's going to be like kind of the formal hearings are very similar to trials. So there will be opening statements from both parties. I will present my witnesses first, and I'll question the witness. The respondent's attorney has the opportunity to cross-examine the witness with questions, and then following that, the commission will have the opportunity to ask questions as well. So it's going to be 2 sets of questions, and then the commission after each person speaks. And then at the end of the hearing, there will be closing statements from both parties, and then the judge that will be sitting will charge you all with the opportunity, let you know what you're supposed to look at. Then deliberations will take place on what discipline, if any, will be assessed by the individual, by the commission. The commission is responsible for drafting proposed findings of fact, conclusions of law, a proposed judgment, and policy reasons. I believe both parties are going to have proposed findings of fact and conclusions of law, but you're not required to accept either of those. And then the commission will deliberate here on WebEx in front of all of the parties, and then you'll announce your judgment and the hearing will be over. The judge is going to be there to rule on any procedural or evidentiary matters. So if there are objections by either party, the judge will then step in. But the ultimate decision on what happens is left to the commission.
Thank you, Caitlin. And I'm sorry, Anna. Thank you, Anna. I got confused here. So if we start at 8:30 tomorrow, we need to book the whole morning, I guess, right?
Yes, I would block off at least until 11:30. I don't know how long this particular hearing is going to last, but I don't foresee it being an all-day hearing.
So that's 11:30 Central.
Yes.
And 8:30 Central.
Yes, 8:30 Central.
All right. So it's different. And so just be prepared, and it's okay if they make notes during the hearing, right, Anna?
Yes, it's okay to keep notes during the hearing. Also at the beginning, you'll be able to review the notice of hearing and charges that I filed for this matter. So you can take notes during the hearing. Any other questions that you may have will probably be more appropriate for the judge during that matter. Yes,
Okay.
did you have a question?
Yes. Is the state of Tennessee the plaintiff, or am I thinking about this wrong? Who's the aggrieved party here?
So it's the state of Tennessee is the petitioner, which is similar to plaintiff, and then the respondent is similar to a defendant.
All right.
So the licensee.
All right.
Yes, Marcia.
So Anna, if we have questions tomorrow, you're our attorney. Are we able to get advice from you, or will there be another attorney that will be there to advise us?
You're not going to be able to ask questions to me. So I'll check and see who can fill in for that. Typically, I don't do these hearings because of my role, but I'll make sure that someone is there to answer questions.
Thank you. The judge will be happy to answer your question. Jeff.
Right.
So Anna, so we're not going to get any information on this case until tomorrow morning?
Correct. The only thing you'll receive is the link for the WebEx to join.
Will the information we receive include what statute are in question as part of this hearing?
Right. So the notice of hearing and charges has that information lined out for you.
Okay, let's, thank you, Anna. Let's take 15-minute break. My mind needs a break. Shalina's mind probably doesn't, but she'll do.
I do.
Okay, just checking. Let's come back at about 25 till the hour. Okay? Enjoy lunch.
Sure. Hey, Joe Begley.
Here.
Jeff, I see you. Oh, there's Joe. And DJ. Not quite back. Marcia, I see Marcia.
Here.
Steve's here.
Pardon my delay.
Oh, there's DJ. John looks to be still away from his computer. Joan is back. I think we're just Stacy. I think we might just be missing John and Stacy.
Stacy had a doctor's appointment, so I expect she's headed that way.
Okay.
But
yeah,
you may join
she's
us
not on.
audio only. All right, let's get back to work. Case 54. This is, I put this on here. What it appears to me, and Shalene disagrees with me, perhaps, This appears to me to be a sale between a buyer and a licensee who's selling his or her own house. And
yes,
some of the conditions that were required in the contract were not fulfilled or completed by the seller / licensee. In my opinion, if I've stated that correctly, Shalina.
yes, that's correct.
In my opinion, this is a contractual dispute. Even though the seller is a licensee, I just have the opinion that the licensee ought to be able to sell their own property, and if they don't do something in the contract, it's not necessarily a violation of the rules and regulations of the Real Estate Commission, but more a contractual dispute. So, with that said, Shalina, you've got the floor.
Well, yes, Chairman, I do agree with you that this is a contractual dispute. However, when I was reviewing this, I determined that because this was a owner agent seller, I was holding them to a bit of a higher standard, and that's why my recommendation is to open a contested case hearing and assess a civil penalty for failure to exercise reasonable skill and care in providing services to all parties in a transaction.
And really, that's what's in front of the motion. Is a licensee held to a higher standard when they're selling their own property?
Chairman, I would say that our obligations are to customers under our license, but if we're selling our own home, I think that changes the equation in my mind a little bit, as opposed to when you're selling somebody else's home.
Okay, other comments?
Yeah, I pulled this one because I can see both sides. I appreciate both of y'all's remarks so far. I pulled it because having sold my home several times, and I felt like I needed to go above and beyond to be above reproach across all boards because I am a licensee. I do know how to sell my own home, but so I think that they're in keeping with protecting the consumer. When you're selling your own property, there needs to be the same amount of effort that you would do and provide as a professional with selling a client's home. That same amount of level and care needs to be when you have a personal interest in the property.
Steve,
did the seller disclose that he was also, or she was also a agent?
Yes, yes, all proper disclosures were made.
Right.
So the chair would love to get a motion, and I don't feel strong about this either way. I just would like to get this one moved on and we'll get going.
Mr. Chairman?
Yes.
So I guess I'm wondering what parts of this did Selena feel like was failure to diligently exercise reasonable skill? What part of it?
The main things that I identified here was that there was supposed to be a HVAC certification for the system, and that was never done. And the respondent just said respondent was waiting for the closing before providing that certificate, when that certificate should have already been provided. And then the other thing I noticed was the respondent did not clear out all of the items from the home on the closing date, meaning there were still items that needed to be removed from the home.
Okay, I agree with Ms. Brown's, and I'd like to make a motion that we accept council's recommendation.
Is there a second? John Moffett seconds the motion. Okay, discussion. Steve, do you have something?
I just don't. I think I'm going to vote against this. I don't think just because the agent happened to be the seller or vice versa. I'm kind of with you, John, and it's between the buyer and seller.
Okay. Other comments? All right, let's vote. Let's vote. If you're in favor of the motion, which is to accept council's recommendation, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Joe Begley?
No.
Diaz?
No.
DJ Ferris?
Yes.
Marcia Franks?
Yes.
Glenn?
No.
John Moffett?
Yes.
Joan Smith?
No.
Casey Torbett? John Grease?
Oh. What's that total look like?
5, 2, 3, the noes have it.
Okay, so the motion fails. Now,
We dismiss this case.
I have a motion by Mr. Diaz, seconded by Joe Begley, that the case be dismissed. If you're in favor of that motion, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Joe Begley?
Yes.
Jeff Diaz? DJ Ferris?
Aye.
Marcia Franks?
No.
Steve Glenn?
Yes.
John Moffett?
Yes.
Joan Smith?
Yes.
John Grease?
Yes. All right, that motion passes.
I'm back on here, by the way.
Okay.
I just had to join from my phone, but I couldn't hear this the last one, so.
We'll put it down as a
on
yes.
that, and then
All right, 55, DJ.
I just needed this one further explained to me. It looked like everybody was agreeing to a closing, and then something came up here where it said the seller would provide keys later that day. This occurred when the buyer was driving. As a result, the complainant canceled the closing. So is that like, does that mean the contracts or just the closing?
The complainant buyer wanted to cancel the contract because the keys weren't being provided at the closing. They'd be provided later in the day or the following day, and that was unacceptable to the buyer. So wanted to cancel that contract.
Why did they not have the keys?
I'm sorry?
Why did they not have the
The seller didn't turn the keys over and was planning on removing some more items as well. And said that it either be provided later in the day or the following day. So based on that, the buyer or the complainant wanted to cancel the contract.
And were they able to do that, or did it close?
It did not close, no.
I don't see where the respondent failed to reasonably provide services. I mean,
Well, the issue was mainly with the mutual release. The explanation on the mutual release was incorrect, and that had to be corrected. And it was corrected, but initially it wasn't. And the complainant did receive the return of all earnest monies.
So if they were made whole, why were they complaining? Did it take a long time to be made whole or something? I mean, it sounds like they're pretty tough to deal with to me. If you can't work out, if you're ready to close on this day and you walk away from the deal, y'all can't figure out if they're going to leave today before closing, or you're just going to close tomorrow when they're out and you can do your final walkthrough. I mean, it sounds like that's a pretty tough client right there.
Agreed.
Yeah, that was the issue, as well as the fact that the mutual release had the error in it concerning why there was cancellation of the contract.
I make a motion to close this case.
I'll second it.
Okay, I got a motion by Joe Begley, seconded by DJ Ferris, that the complaint be closed. Discussion. Since there is no discussion, when your name is called and you're in favor of the motion, you'll vote yes. If you're opposed, you'll vote no. Caitlin.
Okay, Commissioner Joe Begley,
Yes.
Jeff Diaz,
Yes.
DJ Ferris,
yes.
Marcia Frank,
Yes.
Gwen,
Yes.
John Moffett,
Yes.
that was up. You. Joan Smith,
Yes.
Stacey Torbett,
Yes.
John Grease.
Yes. All right, that motion passes. Number 57. Without belaboring the point, here we have an acknowledged advertising violation. But they admit it was a mistake, but it was an advertising violation. Council thinks a letter of warning is sufficient. I like to treat this as like a first offense on advertising, which I think carries with it a $500 civil penalty. And so my thought on this one is, this is more than just a letter of warning. There ought to be a civil penalty involved, as equal to what we normally do with a first offense. Shalina.
Chairman, if that is your will, then I guess the board can make a determination if that's how they'd like to proceed on this matter.
First, open for motion.
I'd like to make a motion that you said to close, right, John? No, only the $500. Excuse me. That we assess a $500 civil penalty on this case.
Is there a second? Joe Begley, seconds. Discussion.
I'd like to make a friendly amendment to that.
Okay.
The motion, I'd like to add advertising. Have it not count towards their CE.
Did you say that again, Jeff?
An advertising corp.
Do we have an advertising course?
I don't know of just an advertising course. Probably need one, don't we?
I guess.
Can we call Bobby?
I guess advertising rules are talked about in the core class, I guess, but I don't know that for sure. Well, anyway, the motion on the floor at the moment is a $500 civil penalty. Steve, did you have a comment?
Yes, question. Again, this is about a sign. Did we see a picture of the sign in question? Meaning, do we know specifically, it says the letters were twice as high as they should have been, as the name of the brokerage. And the respondent said it was a misprint. So I'm wondering if we actually looked at it to see, was it twice as high or was it an inch off? And maybe it is a misprint. I don't know. I'm just asking the question if we see any evidence or picture of what the complainant is alleging.
Yes, a picture was provided, and what the complainant alleges is correct. But it was a misprint, and the sign was removed. That's the only explanation the respondent had.
The other point of this is the principal broker should have approved it.
Well, I mean, unless you look at the copy and the sign company could have screwed up. I don't, there's a lot of ways to screw a sign up.
And this, it says real estate broker, so the principal broker that we're talking to here now anyhow.
Yeah, I don't belabor the point, but the law is pretty clear on it. Your name can't be any bigger than your company name, period. So let's vote. The motion is to offer a $500 civil penalty. If you're in favor of that motion, vote yes. If you're opposed, vote no. Caitlin?
Joe Begley,
Yes.
Jeff Diaz,
Yes.
DJ Ferris,
Yes.
Marcia Frank,
Yes.
Steve Glenn,
Yes.
John Moffett,
Yes.
Joan Smith,
Yes.
Stacy Torbett,
Yes.
John Grease.
Yes. Motion passes. Number 58, I'm going to be quiet for a while, talks about negotiation that went back and forth verbally, not put in writing. Correct, Shalina?
Yes.
And so the council's recommendation is to issue a letter of warning. And my sense is, and I know there may be extenuating circumstances in this case, but no deal should be negotiated back and forth verbally, that it should be in writing at some point, at least during the negotiation. And I don't think that ever happened. So I don't know if a letter of warning is strong enough, or is this a violation of using reasonable skill and care? Those are my thoughts. Y'all feel free to speak.
Let me just state that the only reason I said a letter of warning was due to the extenuating circumstances of the respondent having open heart surgery. And that was the only reason why I recommended a letter of warning.
And was it the day he was having surgery or a couple of days afterwards, or was it 6 months ago?
I'm not quite sure of the date. The date of the surgery was in July, and it was the respondent was on bed rest at the time. So this communication was being done when she was in recovery. She or he.
Feels like we're fighting the urge to be merciful.
See, that's the difference between Shalene and I. I'm going, that's not a good reason. He's got a broker, he's got other licensees, and the company could help him or her. And the law department, legal goes, man, those are tough times. Let's give him a break. So which way do you fall? Okay.
Make a motion to accept the letter of warning.
I mean,
who made that motion? Joe did. Motion is to accept council's recommendation. John Moffett seconded that. Is there discussion?
Well, Mr. Chairman, I guess in response to your statement, we know that there are more agents and brokers for this agent to turn to. Do we know that?
They're an affiliate broker, so they have to have a principal broker.
Jeff, my feelings won't be hurt if this motion passes. It's on the floor. We've got more pressing issues perhaps to get to. So let's go ahead and vote. If you're in favor of the motion to accept council's recommendation and send a letter of warning, you'll vote yes. If you're opposed, you vote no. The chair would like to vote first. Caitlin.
Okay, Joe Bagley.
Oh, no. The chair would like to vote first.
You don't think we should go in the same order we always go in?
No, not on this one. I want to vote yes, get it out of the way. Okay. Now call the roll.
John Grease.
Yes.
Joe Bagley.
Yes.
FDS.
Yes.
DJ Ferris.
Yes.
Marcia Frank.
Yes.
Steve
Close
Quinn.
my door. Close my
Yes.
door.
John Moffett.
Yes.
Joan Smith.
Yes.
Stacy Torbett.
Yes.
All right, the motion passes. Number 60, DJ.
These all 60, 61, 62 all seem to be individual complaints, and I just was going to say I move to accept council recommendation on all of these 60 through 62, but I didn't catch it when we voted earlier on the consent agenda that 61 and 62 might have been lumped in with those already. So
Your motion is to accept council's recommendation on case 60, correct?
Second it.
Seconded by Ms. Franks. Discussion. Ms. Maxwell.
Joe Bagley.
Yes.
Jeff Diaz.
Yes.
DJ Ferris.
yes.
Marcia Frank.
Yes.
Steve Gwen. Is that a yes, Steve?
Yes.
Okay. John Moffett.
Yes.
Yes.
Joan Smith.
Yes.
Stacy Torbett.
Yes.
John Grease.
Motion passes. Number 63, DJ, is this one of yours?
Is, and I wanted to take this moment, as you've mentioned it, Chairman, about all the timeshare issues. I was picking up the same thing. I know all of the commissioners were reading these and saw how many timeshare complaints. And I just wanted to make vocal my thoughts that are we as a real estate industry in Tennessee doing the best we can with regards to how timeshares are operated in our state. This complainant and this particular one is a resident of Washington State, so I can't really help them too far, as they're so far away. But if this respondent is a timeshare registrant in Tennessee, for what they do in our state, there certainly appears to be a huge gap in the service being rendered for consumers looking to do timeshares. And I just wanted to take this particular one to make an opportunity to pose that to our commission to, I don't really have any recommendations, but I'm certainly not signing up to teach timeshare operations, but wow, I mean, this whole process has opened my eyes to how timeshares are ripe for abuse and just extortion or whatever. So having said that, move to accept council's recommendation.
Seconded by Marcia. Discussion. If you're in favor of the motion, Steve.
I just on DJ's point, is there a way to get an understanding of what size the timeshare market is? I have no idea how prevalent this is, how many people we're talking about. Is there a way to find that out, or not?
Marcia, help us.
I would say it's prevalent nationwide, not just in the United States, Canada. So this is a problem. What I would suggest, and we all agree, we need to all know more about it because we're having to sit in judgment on these people. The few timeshare meetings that I have gone to at Arello, I see that the same problem everywhere. We had a director, two directors before the one we have now, Eve Maxwell, and Eve was also an attorney. And she also chaired the timeshare committee at Arello, and that was great insight for her to have that insight into what is going on in timeshares and what can we do. It's the reason that Arello decided we had to do something for everybody, and we made these videos to help people get out of these contracts. I would encourage every person that's on this board is a member of Arello, and I would encourage someone signing up for the timeshare committee just so that we can have someone with some expertise. We don't have timeshare expertise in our commission. So that would just be a suggestion. That's the only thing I know that we could do to help ourselves at this point.
Marcia, I was kind of trying to wonder if is it limited to mountain homes and beach homes and that kind of thing, or is it in every county in Tennessee? My guess would be that it's mostly in East Tennessee where there's mountain vacation places, but I don't know that for sure. It'd be interesting to if there's any way to get a handle on it.
Usually it's not just specific to one property. Earlier we had one that was in Mexico. So if you buy into this, you can use your time at anywhere where this company works. I will tell you that it seems that the majority of these people are older people. They don't want to totally buy out a condo for a second home, but they don't mind spending a little bit of money because they're probably on a vacation. Somebody comes out to the pool and says, if you'll come to this presentation, we'll give you something. And so they're like, what the heck? Let's go see about it. And so then, they don't make great decisions. And then by the time they figure it out and they tell their kids, it's too late for them to get out of it. And that's basically what I'm seeing. You're not seeing a whole lot of young people signing up for timeshares anymore, sadly.
Thanks, Marcia. So, Steve, I'm looking at the executive director's report, and by profession count, there's somewhere around 1,200 licensees as of October in our state for either timeshare exemptions or timeshare registration or timeshare sale. And I'm just looking at all the complaints and thinking,
well, if we can map out where those 1,200 people are, by county, that would give us, because they're going to be wherever the real estate's located.
Most of the timeshare Tennessee are in East Tennessee.
Right. Yeah.
We don't have many in Middle Tennessee. We don't have you don't have many in West Tennessee.
Joe.
I'm going to put myself out there a little bit about 45 years ago, Danny and I invested in a timeshare and started that process in East Tennessee. And we attended one of those. So I have compassion for these timeshares than probably any of you. And we attended one of those meetings. And I think the price at that time was $12,000 or so for a week. And we were just astounded. We didn't have that kind of money. Probably still don't. Anyway, on the secondary market, we were able to buy something for about $1,000. We jointly bought one of those with another couple and enjoyed that investment on the secondary market. And over the years, we bought on the secondary market and attended those meetings. And we attended those meetings with some high pressure, to say that word, intimidation. So I really have some strong compassion when I read these complaints, almost with tears in my eyes. And we bought several weeks of timeshares and used them fully for years. We have in the past have sold most of those on the secondary market. And I'm not complaining because we stayed in some very nice condos, but we never paid what these people are paying. It brings tears to my eyes. So I'm not sure what the answer is, but I just can't help but feel compassion when I read these complaints. I don't know how to help these people. It bothers me when I see these complaints from these people that are trying to sell these timeshares for people, and they're being taken advantage of. I don't know what the answer is, John or Marcy. I don't know what the answer is. But when you get someone who is not familiar with the words of no, when you go into these meetings and they don't know how to get up and walk away, and you're being told you can have these vacations, all you have to do is sign on the dotted line. Here are these wonderful condos. It's very difficult to walk away. So I don't know what our role is as commissioners, but I do think when we see these many complaints, we need to do something. I'm not sure what that is.
So just a couple things. We'll move on. First of all, in almost every case, when a complaint is filed against a timeshare company, the timeshare has all the paperwork correctly filled out, rights of rescission have passed,
right?
And there's nothing we can do if we want to. Number two, I want to talk to Steve for a second. You'll find this interesting. You're talking about where timeshare might be located. As an example, there's a new hotel in Nashville called Margaritaville, downtown Nashville. I'm making this part up. It's 12 stories tall. Timeshare company is renting the first 8 floors. And so you can buy a timeshare in Gatlinburg and use it to stay in Nashville. Or you can buy a timeshare in Nashville and use it to travel anywhere you want to. So timeshares a lot of times are a place where people want to be. The Smokies are a great place for timeshares to be, but people want to be in downtown Nashville too, and all over the place. So it's everywhere. It's an amazing concept. So you got 6 floors of timeshare and 6 floors of hotel above that. And timeshare operators, if the hotel rooms don't get full, get to put their clients up in some of those rooms. It's a cross of 2 different uses in one building. In any case, I got it. I've tried for 8 years to understand timeshares, and since I do, they start talking about vacation clubs. And I don't know what the difference is. Someday I will. Marcia?
I'm wondering if at our next meeting, if we could get someone like Mark Green or someone to come in and discuss this with us. Our attorneys know more about this than we do. And, I just like for them to come in and talk to us about, what can and what can we not do, or to try and help us out with this matter a little bit.
Yeah, I agree with that, Marcia. And the gist of these complaints that I read, the respondent, the tone seems to be like, hey, it was in writing. They signed it. Too bad. And that's, far as how residential brokerages practice, those problems are mass problems of representation and how things are conducted in the sale of a home. Those big consistent problems have been largely weeded out by the the staff attorneys at TAR and the NAR, and it just things just it used to be buyer beware. That was the whole line we would hear often. That's not the case anymore. And so timeshare, it appears to me, needs to undergo the same type of reform. So that's all my say on that.
I think it's a great idea, Marcia.
But here's the deal. They can explain it to us, but we can't do anything about it. This is a legislative issue, not a regulatory board issue, I don't think. And I'd be hard pressed to believe that Mark or Anna or Shalina or any other attorney, Pamela, is going to come up here and say they know everything about timeshare. It's a tough concept to fully understand. But with that said, Caitlin, if you can find somebody who can talk to us about timeshares, even a representative of the industry would be helpful. That would be great. I'd love to talk to them. Caitlin, can you put that on your list of things to try to do?
Yes, I will put it on the list.
Thank you. All right, let's vote. The motion was to accept council's recommendation. DJ, that was your motion.
Yes.
Okay, let's vote. If you're in favor of the motion to accept council's recommendation on case number 63 and close that case, you'll vote yes. If you're opposed, you'll vote no.
Okay, Joe Begley,
Yes.
Jeff Diaz,
Yes.
DJ Ferris,
Yes.
Marcia Frank,
Yes.
Steve Gwynn,
Yes.
John Moffett,
Yes.
Joan Smith,
Yes.
Stacy Torbett,
Yes.
John Grease.
Yes, that motion passes. We're on to case 72. DJ.
Excuse me, Chairman?
Yes, ma'am.
If we could please return to number 63, I have a correction to that. That firm is actually licensed, number 63. I believe you took that as a block, 61, 62, and 63. But 63 is licensed and should be closed.
I think that's outvoted.
Okay. I'm sorry, 62. I'm sorry, 62. We
Okay,
took
60.
60, 61,
Oh, yeah.
62, but 62 is a licensed firm and should be closed.
Thank you. So we're going to reconsider case 62 just for a moment. We have some updated information that indicates that I totally agree with this, that this case should be closed. So is there a motion that occur? Made by Joe Begley, seconded by DJ Ferris. There was conflicting information in the narrative, but it's fine. The motion is a perfect motion. If you're in favor of closing this case, number 62, you'll vote aye. If you're opposed, you vote no. Caitlin?
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Franks,
Aye.
Steve Gwynn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grease.
Yes, the motion passes. Let's move to case 72. DJ.
Earlier, I had a case and there was no other information to show that it was only more than one instance, and that was the reason I brought up this one as well. So if there's no other instances or information to suggest that there were more than one instance of this respondent who is not licensed marketing homes on Facebook, then I move to approve of the $1,000 civil penalty.
Is there a second? Steve Quinn seconds it. The motion on the floor is to accept council's recommendation. If you're in favor of that motion, you'll vote aye. If you're opposed, you'll vote no. Caitlin.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Franks,
Aye.
Steve Gwynn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye. And I'm going to have to get off for a bit. I'll call back in.
John Grease.
Yes. The motion passes. Number 75.
Mr. Chairman,
Yes.
I've got to leave and go to, I'm speaking at an NAR meeting. Could we jump to number 79? That was one of mine.
Sure.
Possibly.
Let's go do 70. We'll go back to 75.
Okay, so my question on 79 was, it says that they had no intent. And it was like they didn't know what they were doing, and so they had no intent. But it doesn't say that they didn't violate the vacation lodging service firm. So I would say, I would like to make a motion that instead of closing this, that we assess a $500 penalty because they did violate that vacation lodging service.
Shalina.
Yes.
Anything you want to say to that?
The only thing, they did mitigate the problem and stop the practice, and yes, there was a violation. So,
okay. It's an advertising violation, basically.
Yes.
Okay, which would fall into what we typically do. So the motion on the floor, offered by Ms. Franks, would, if accepted, offer this vacation lodging service firm a $500 civil penalty. Is there a second to that motion? Jeff Diaz seconds the motion. Discussion. Let's vote.
Joe Begley, Joe Begley,
Yes. Aye.
DJ Ferris,
Aye.
Marcia Franks,
Aye.
Steve Gwynn,
Yes.
Joan Smith,
Aye.
John Moffett,
Aye.
John Grease.
Yes.
This is Jeff Diaz. I didn't hear my name, but I vote aye.
Mr. Chairman, I'm sorry, but I'm going to drop out at this point.
Can you stay one more minute? One
Yes.
more minute.
Okay.
Let's go to 78 quickly. 78, if I understand it correctly, Shalina, if somebody falsified education records and sent them to the state to satisfy their education requirement, is that correct?
yes.
We've never had that before.
Never.
And I don't want, whatever we do here will be a precedent. for any other licensee who decides to take it upon themselves to create records saying that we're in a class. And so I'd like to get the commission sense or Marcia's before you leave about this situation.
Well, absolutely, this is wrong. And I would agree with council's recommendation. I don't know what we do to make sure that this never happens again. It just seems we have so many education providers right now. I'm wondering, did Ross find this discrepancy, or how did we know this happened? Did somebody, because the complaint was opened administratively?
I can chime in a little bit on this one. So education is required to be sent by the provider. And there's a reason why we do it that way. And I think it's probably to prevent instances like this. This particular licensee tried to send their certificate, and we stated that they have to have it sent by the provider. So we then sent the certificate to the provider, and the provider had no record of this licensee, and also did a lot of looking into this with us. And they are who determined that they had falsified the certificate, because they have, records of exactly when a licensee takes the course. And it appeared there was also a false course code used on one of the certificates.
And we know that it's just one time, Caitlin?
I believe they attempted to send in a couple certificates.
So what's the maximum we can do here? I'm asking legal.
$1,000.
For each certificate submitted, you could assess a $1,000 civil penalty.
And if you thought it was bad enough, you could suspend a license for a period of time.
I think it's terrible. I can imagine. I mean, it's not like, oh, I accidentally sent in the wrong one dated last year. It was like,
it's forgery.
I feel like it was pretty intentional, right? Whoever did the administrative investigation, you feel like it was pretty.
I mean, has anybody on it? Has any commissioner had to send? Any commissioner had to send a certificate to the TREC to get education credit, and maybe to prove education credit, but not to get it themselves, right?
Right. Floor is open for a motion.
Respondent claimed that they had been scammed.
They got to always blame somebody. I'm interested in knowing how many certificates. Was it 1, 2, 3, or what? And I'll make a motion.
I've got a question at some point.
Okay.
Now?
Not yet.
Okay.
Shalina,
Yes.
you're looking for how many certificates?
Yes, we're checking how many certificates.
Okay. Stand by.
It looks like there's 4 certificates. I'm sorry.
Quickly, Shalina.
It looks like there were 4 certificates.
Okay, I'd like to make a motion that we assess $4,000 civil penalty against this person for the 4 different certificates that they falsely made.
Is there a second? Steve wins seconds. Marcia, if you have to go, you have to go.
Yeah, my vote is yes. Sorry.
Okay. But it may change. We'll see.
Okay.
We'll be able to come back and see us.
Okay.
All right, Steve, you've got the floor.
I got a question for Shalina. The the code section you cited there, what does it say?
This is under.
Are you kind of lumping this in some kind of truthful honesty code, or is there? Okay.
Yes, it's under disciplinary action that the board can take against licensees, and one of the provisions, provision 1, is the licensee making a substantial and willful misrepresentation.
Got it. All right, perfect.
Okay, Jeff Diaz, any comments?
Well, I think, I'm okay with the civil penalty, but I think some kind of suspension order. I'd make a friendly amendment to the motion that we assess the civil penalty and suspend their license for 6 months.
Okay, is there a second? Mr. Bagley seconds that. So now the motion on the floor is a $4,000 civil penalty and 6 months license suspension. Discussion. All right, I sent you ready to vote. Caitlin. Hey, Bobby.
John.
By the way, if you favor this motion, you'll vote yes. If you're opposed, no.
Yes to both.
Okay.
Hey, there's Bobby.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Steve Glenn,
Yes.
John Moffett,
Aye.
Joan Smith,
Yes.
Stacy Torbett, John Grease.
All right, that motion passes. Let me remind commissioners that it's an offer to the licensee, and he does or she does not have to accept it, and instead may choose to come to a formal hearing, which we're happy to entertain. For those of you who are here for the rulemaking hearing, we'll get to you shortly. We'll get the rulemaking hearing shortly, and your comments. Number 80.
Chairman, Chairman, if we could return to 78, I'd just like to remind the commission that this will be presented to the respondent in the form of a consent order. The suspension will not be automatic. Right. If the respondent accepts it, then it will be a suspension. Otherwise, we'll have to go to hearing to get the suspension in place.
Understood. Good point.
Okay, I think we skipped 75.
Yep. Let's go to 75.
I move for council I move to accept council's recommendation on that.
Is there a second? Second, Jeff. Okay. Discussion. Let's call the roll, Caitlin.
Joe Begley,
Yes.
You called my name, I vote aye.
Yes. Yes.
DJ Ferris,
Yes.
Marcia Franks, Steve Glenn,
Yes.
John Moffett,
Yes.
Joan Smith,
Yes.
Stacy Torbett. Okay.
Yes.
You have it 7 with 2 absent.
Okay, let's move to number 80. So we got 3 or 4 cases here that have been presented in the past. This is a case where an agent in a firm without the authority of his broker or her broker was running his or her own property management company and got caught. And this commission at some point in the past authorized a certain civil penalty. In the meantime, legal got additional information, and that additional information, as I understand it, Shalina, was that the guy or girl has quit being in the property management business, given all money back to the parties that were affected, and the complainant wishes to withdraw the complaint. Is that a pretty good summary?
Yes.
And so here's my problem. Clearly, this licensee was violating the law. And the commission in the past thought it was grievous enough to offer a $3,000 civil penalty. Now that he got caught or she got caught and has corrected everything, he still, or she still broke the law. And so, but I couldn't hear. So, because he got caught or she got caught and corrected all the mistakes he or she made, doesn't make me feel a lot better about what he or she didn't start with. And so I'm inclined to accept, to stick with the original recommendation from legal. Even though people have been made whole, that the violation of rules and laws did occur. So that's my thought on that. Any discussion or motion?
Chairman, the only thing I'd like to add is the complainant is not willing to go forward in a hearing situation, and that could be a bit of a problem for me in order to prosecute this case, because ideally I'd need the testimony of that complainant concerning this matter. So that's my issue in this complaint.
Shalina, typically there isn't a formal, the only way that we can dispose of this is either by closing it or having a penalty. The complainant doesn't have the ability to withdraw a complaint. Is that correct?
Typically, yes, the commission does not withdraw complaints, but if I don't have the cooperation of witnesses in a hearing, then it makes it very difficult to move forward because there's not enough proof to prove the allegations that are stated in the complaint. Alternatively, we could close and flag this matter just to keep it on our radar.
So let's say the complainant won't testify. We're making the assumption that the licensee will not accept the consent agreement, which may be a good assumption. I don't know.
Yes, since the respondent hasn't accepted it to this point, and I know that we have followed up, they are not accepting this informal settlement offer.
So your recommendation is to close, but you'd be okay with closing and flagging it?
Yes.
All right, commissioners, I think that's a fair compromise based on this unique set of circumstances. And future licensee ought to hang their hat on what we're doing in this case.
Motion to close and flag.
I'm back on, just in case y'all need to know that. I'm back.
Good deal, Stacy. Is there a second to the motion? Joan Smith seconds that motion. Discussion. Let's vote. Caitlin, please.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Marcia Franks, Steve Glenn,
Aye.
John Moffitt,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
I'm going to pass since I just got back on.
John Grease,
Yes. All right, that motion passes. Number 81, Shalene, I just have one little problem with this.
Okay.
So you've suggested two $1,000 civil penalties, but it appears to me that the respondent is not licensed. If the principal broker referenced here is not licensed, then I think the only charge we can consider is selling real estate without license. Think about that.
Yes. Yes, sir, that's correct. This should be revised for only unlicensed practice of real estate.
Is that your recommendation?
Yes.
Okay, is there a motion to accept council's recommendation?
So moved.
Diaz makes a motion. Joe Begley seconds. Discussion. Let's call the roll.
Joe Begley,
Yes.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Steve Glenn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grief.
Yes, that motion passes. 82, DJ.
I move to accept council's recommendation.
Is there a second? Jeff Diaz seconds that motion. Discussion. Caitlin, please call the roll.
Joe Begley,
Yes.
Jeff Diaz,
Yes.
DJ Ferris,
Aye.
Steve Glenn,
Aye.
John Moffett,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grief.
Yes. All right, that motion passes. And lastly, number 88. Erica, welcome.
Thank you.
Good to see
I've
you.
been here.
Okay, in that case, good to see you. All right, so Erica, when we have a case here where clearly an agent made a side deal with the buyer to collect additional commission after closing that did not go through his or her broker.
No, not at all. My apologies if that seemed to be the case. The facts are there was a $2,000 bonus to the designated agent, which is the respondent, laid out in the contract. It was it literally said commission to broker plus a $2,000 bonus to the agent. And when closing happened, the buyer admitted that he had spent, like, it was a cash deal completely, that he just didn't have it. He spent it and he was sorry. And then wanted to keep their word and was able to send it the next day, like electronically.
He sent it to somebody besides the agent.
Right. And he sent it to the respondent's attorney. And the money was never given to the agent. The agent never had control of the money. It's always been in the respondent's attorney's trust account. And that's where it remains, because the plaintiff, who is the principal broker, refused to sign a form that said it was accepted and fired the respondent that day.
That's because, in my opinion, that's because the agent had a side deal where the money was going around his or her broker to his or her attorney. What do you think about that?
I mean, I don't know how to prove it was a side deal if it's accepted on the exclusive agency agreement.
Well, the agent in every case is the company, not the individual. Wouldn't you agree with that?
Well, the broker, yeah, I agree. But in the contract, it also says the broker appoints the designated agent in this transaction.
But nowhere in statute does it allow the commission to go to anywhere but the agent's broker.
Well, and that's what I wanted to talk to you guys about, because I reviewed all of the rules and statutes and I can't find it anywhere that this is, I mean, it might seem shady, but I can't find that this is a violation.
Matter of fact, we sent a letter to Herb Slattery today asking this question. But the difference is the broker never authorized commission money to be sent to anywhere else. Only the broker, under some interpretation, might be able to do that. That's what I think.
And typically, commissions that are stated on a contract aren't really that valid. There's a separate commission form between two brokerage firms that state how commissions are going to be paid. It's unusual that a buyer is going to pay a side commission unless there was a buyer's agency agreement and they were agreed to pay a certain percentage plus a bonus if somebody found them a house. It's a weird situation all around.
But even in that case, Joe, the money would go to the broker to distribute back to the agent. So anyhow, that was my issue, Erica. The money didn't go to where it should go. And it went there, it went where it shouldn't go with the direction of the agent, which I think is a violation.
So it should have been, I guess, does that mean after, like if it doesn't happen at closing, it shouldn't be accepted by the affiliated broker? It has to go directly to the firm, and if the firm doesn't attempt to get it, they just don't get it?
I think that's why the statute is so clear. It says all commissions have to be paid by the agent's broker. And a bonus is a commission, in my opinion.
Okay.
That's
a commission.
Now,
Okay,
Anna,
I see what you're saying.
you do? Way to go. Commissioners, what are your thoughts?
I agree, Chairman.
I personally think that there's more to the story between the broker and this agent because
That's what I think.
There's like the end of the first paragraph talking about a police report, third party not hired by the firm, and I think that
I believe the agent thought they were never going to get this bonus, which was supposed to be 100% paid to them, and did this because it was already in dispute before it was collected for whatever reason. So, I mean, if the agent accepted it directly, it's definitely a problem. But I just feel like they immediately put it into a trust account for the courts to decide a dispute about the commission for the civil court.
But the law doesn't give a licensee the latitude to do that.
Okay, so
my
I'm going to amend my recommendation for $1,000 civil penalty for violation of 62-13-312B11.
Did you just make that number up, or do you really?
Anna's helping me. I got to give that to Anna.
Okay.
Motion to accept council's recommendation.
Motion by Mr. Diaz to accept council's recommendation. Is there a second? John Moffett seconds that motion. Is there further discussion? Let's vote. Caitlin.
Begley.
yes.
Sorry, I didn't catch you, Joe. Okay, Jeff Diaz,
Yes.
DJ Ferris,
Yes.
Steve Glenn,
Yes.
John Moffett,
Yes.
Joan Smith,
Yes.
AC Torbett,
Yes.
Reese.
Yes. So that motion passes. Erica, thank you. Let me say this to commissioners. Again, I want to encourage you, prior to our meetings, if you have questions about particular cases, legal is happy to get your questions in advance. It helps them. You may make a valid point or you may not, but as you review these cases and would like more information, I think Shalina will tell you that I wear her out with certain questions. We don't necessarily agree, but what it does do is hopefully shorten the meeting somewhat, because if I send her 6 cases and don't understand what a recommendation is, and we come to an agreement on 3 of those, then that's 3 less cases we have to hear during a meeting like this. And I will tell you that Shalina and Erica, are you about done with us, Erica?
Oh, yes, I'm done.
Forever. Is this your last meeting?
I have a formal hearing with you guys December 10th. Anna has one as well, I believe. And I've got one other case that needs a formal hearing that I'll be filing any day now, and then I'll be done.
Well, so we'll still see you. So my point is, if you have questions, whenever I send a question about these cases, I copy Anna, Shalina, Erica, and Caitlin. And so everybody, the law department gets to see, and Caitlin and I get to see the response. It's a helpful tool to streamline these meetings. And you might be thinking to yourself, if you would just shut up, the meetings would be a lot more streamlined on their own, but that's the way it is. Anyhow, with anything else from legal before we
yes, yes, Chairman, I have 2 items. I believe we skipped 82, but going back to 81, you amended that my recommendation for unlicensed activity, and there was a $2,000 penalty because I had 2 violations, but I'd just like to clarify that it's a $1,000 penalty for the unlicensed activity on 81.
Okay, is there such a motion? Joe Bagley makes a motion to amend the recommendation to $1,000 civil penalty. Joan Smith seconded that motion. So that we're legal, let's vote quickly. Caitlin, if you're in favor, vote aye. If you're opposed, vote no.
Joe Begley,
Aye. Aye.
Jeff Diaz,
Yes.
DJ Ferris,
Aye.
Steve Glenn,
Aye.
John Moffitt,
Aye.
Joan Smith,
Aye.
AC Torbett,
Aye.
John Grease.
Yes. Okay, that motion passes. DJ, I'm sorry I skipped 82. You want to talk about that?
Chairman, you didn't skip it. I moved to accept council's recommendation and we voted on it.
Anybody else agree with DJ that we voted on it? Because I don't remember. We did.
Yeah, I have to vote for it.
Okay, perfect. That's good enough. All right. Anyhow, Shalina, don't bring us 85 cases next month, will you? Or 88 but the fact that you did it and handled them, you did well. Thank you for your help with this.
Thank you.
You're welcome. We're going to the rulemaking hearing now. Anna, lead us through this.
Okay, did you want to proceed with the rulemaking hearing or what's left of or commission discussions?
I don't think we don't have anything on the agenda under commission discussion.
Okay. Wanted to make sure we can proceed to the rulemaking hearing then. Hold on 1 second while I pull up the script. Denny, are you ready?
I am. If I could just ask everybody to mute their microphones while we go through this, it will make it a little clearer. And then also please to give your name before you speak because I'm not familiar with everybody. Thank you.
That is our court reporter that is going to be taking a transcript. So I will begin now. Also, just bear with me. This is my first virtual rulemaking hearing, so I hope it will go well. This rulemaking hearing is called to order. My name is Anna Matlock. I serve as an Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Real Estate Commission. With the agency representatives who are present, please introduce themselves for the record. So I'll need the commissioners and executive director to state their names for the record, please.
Joe Begley.
Jeff Diaz.
DJ Ferris.
Steve Gwynn.
Joan Smith.
John Moffett.
John Grease.
Stacy Torbett.
And we have the executive director, Caitlin Maxwell, is here. Today is Thursday, November 12th, 2020. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 5-4-204 via Cisco WebEx, the video conference platform. The purpose of this rulemaking hearing is to solicit comments on two sets of rule amendments to the rules and regulations of the Tennessee Real Estate Commission. First, the proposed rule is an amendment to the advertising rules set forth by the Commission. The rule amends one of the general principles. Previously, the rule required licensees to obtain written permission from the owner to advertise the property listed by another licensee. Now, the rule requires written authorization not from the owner, but the listing agent or listing broker. Secondly, the second set of proposed rules are in response to the enactment of the Fresh Start Act, which is Tennessee Code Annotated Section 62-76-104, that became effective on July 1st, 2018. The rule removes a previous requirement that prevented individuals convicted of any felony or a misdemeanor involving theft of money, services of property, or property from eligibility for examination or licensure unless 2 years from the date of expiration of probation, parole, or conviction, or the date of release from incarceration, whichever is later in time. Furthermore, the rule narrows the individuals required to appear before the Commission for licensure consideration due to a criminal conviction. Currently, the rule requires all individuals convicted of any felony to appear before the Commission. To comport with the Fresh Start Act, this requirement is narrowed from all felonies to those individuals convicted of Class A, B, or C felonies, as those felony classes have a rebuttable presumption that the conviction relates directly to the fitness of the applicant engaged in the applicable occupation, profession, business, or trade. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of Secretary of State. Notice is given to the public for comment.
Sounded like Ella.
Sorry, I'm so sorry.
Was that Ella?
No, that was Quincy.
Okay,
I have to figure out where.
Go right ahead.
Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days. Then end of which time will be the effective date. Those members of the public wishing to speak should place their name in the chat box. Only those who have signed up will be permitted to speak. Oral comments will not be accepted from persons who have not entered their name into the chat box. Is there anyone else that desires to offer oral comments but has not entered their name in the chat box yet? Seeing that there are none, I would call your attention to the chat box now, as I will place the links to the red line that you may view online as we go along. The notice of rulemaking hearings included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on September 4th, 2020. Ms. Maxwell, what additional notice was given to the affected individuals or groups?
Notice was also placed on the website and also sent via Notify.
Thank you. As the agency hears public comments on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. Is there anyone that is possibly on the phone that is calling in that may have a comment?
Hannah, this is Commissioner Diaz. I know that Bobby Wood on the call. I wanted him to be here so that he could restate his rationale for his rule change because he was the one that proposed the rule when he was a commissioner.
Sure. Okay. Is there anyone else on the call right now? Anyone on the call that would like to make comments? Okay. Seeing that there are none, I will summarize the substance of the rules for the record. So the first set of rules that we are going to look at are going to be the advertising rules. This is an amendment to Rule 1260-02-.123E. Specifically, this rule is amended to remove the language property owner. Written authorization must be evidenced by a statement on the listing agreement or any other written statement signed by the owner. So the rule shall read now, no licensee shall advertise property listed by another licensee without written authorization from the listing agent or listing broker. Now I will move to summarizing the second set of rules that we'll be reviewing today that applies to applications for examination. Specifically, this rule is going to be amending Rule 1260-01-.01. Subsection 4 is being deleted. The previous subsection 4 is now, previously subsection 5 is now 4. And the beginning of that subsection states, notwithstanding the provisions of paragraph 4 of this rule, is removed. The new subsection 5, which was formerly subsection 6, amends felony to add the language class A, B, or C felony. Also, subsection B1 amends the background check produced pursuant to TCA section 62-13-303. L does not reveal the disposition of any arrest or charge related to a class A, B, or C felony. Also, a new subsection D will come under this chapter, which states an applicant who appears before the commission requesting licensure and who is denied will not be eligible for reconsideration for 6 months from the date of denial. Okay, hold on one moment.
Anna, you're muted.
Thank you. Before I take public comments, I'm going to read into the record comments that I have received via email. Hold on one moment. Okay, so we will start with comments first for advertising rules. The first comment we have is an email from Miss Diane Farr. The comment states as follows. As far as the rule requiring licensees to obtain written permission to advertise, now to come from the listing agent or listing broker versus the owner, we all want the same thing, a sale. Sellers want to sell, listing agents want to sell their listing, buyer agents want to help sell. So I think it's a win-win. What's really different from this and every Tom, Dick, and Harry agent having the IDX feed on their website showing all listings. They don't have the owner's written permission, but if it's in the IDX feed from the MLS, their listing is already all over the World Wide Web. Not sure if I'm understanding. I mean, personally, I wouldn't advertise another agent's listings without asking them anyway. Do we have any comment from any of the commission members in response to this comment? Okay, seeing none. Next we have a comment from Miss Linda Wagner. The comment reads as follows. I read and agree in general with the rule changes. However, there are a million companies that advertise every realtor's listing on their websites, such as Redfin and Zillow. Most never mention the listing agent or firm, and if they do, often it is so small you can't read it. Unless we are going to hold all of them accountable, I think every realtor should be allowed to also advertise anyone else's listing without permission from anyone, as long as it reads somewhere on the advertisement who the listing is with, the company and the realtor's name that are listing it, which is much less than anyone else does. So we can help sell great listings out there. And again, I think all these big companies that advertise without posting the listing company should be held accountable. But if you look and see it after this restricting licensed realtors at all is not smart. We are at the least trying to sell the listing, then online companies are just trying to generate money for themselves. Go to Redfin and look at it. When I see a great listing at a great price, I would like to at least advertise it to my group of investors without having to get permission. Again, as long as I don't try to take credit for it and I'm trying to sell it as a buyer's agent with the whole rest of the world who are not realtors putting it out on the internet, what is the point of restricting the good realtors from advertising? Do we have any comment from the commission members in response to this statement? Okay. Seeing that we do not have any comment, I will move forward to the next comment that was submitted. This comment is from Tennessee Realtors. Angela Shields is the CEO. This letter is to serve as a formal comment to the proposed change to TREC Rule 1260-02-.123. Tennessee Realtors is in support of this rule change as requiring written permission from the listing agent rather than the owner of the property to advertise the listing of another licensee. Will make it easier for our members to remain in compliance with advertising rules while assisting the consumer by providing more exposure to a property. Tennessee Realtors finds this rule change to be more practical for our members and appreciates the commission for bringing forth this change. Is there any comment from the commission on this statement? Okay, seeing that there are none, Commissioner Diaz, I know that you stated that Mr. Bobby Wood is on the line. Mr. Wood, would you like to proceed with your comment regarding the rule change for advertising?
Sure. Can y'all hear me?
Yes.
Okay. I think it's one of those. I think the original rule came about from how real estate was done 30, 40 years ago. Nowadays, with the advent of the internet and stuff, people are able to advertise. And what some of those comments were talking about, where agents were they were confusing advertising versus sharing of a listing. And for instance, right now, there's absolutely nothing that forbids if you have a client, they're looking for a specific property, There's nothing wrong with you sharing that property with your clients to try to help sell it. But the difference is advertising is when I take that property and say I want to run it in a local newspaper, or I want to push it on social media and I display it as it's my property. That's the difference between the two, between just sharing it and then listing it. But right now, what most of us have with our multiple listing services, we have the ability right now. You can go on any of our websites. I will have listings of other agents right now on my website, and it's through an IDX agreement. And I don't want to get into the bushes on that, but it's an agreement that agents have in the MLS. So it allows me to display other agents' listings. But with the way the current law is, if we were to go to take and I wanted to advertise another agent's property, I would not only ask that agent, but we'd also have to ask the seller. And I truly believe when a seller lists a property with us, they turn over all marketing to us, and they want us to use our expertise and professionalism in getting that property out in front of the public. So I think this is just a rule it's kind of a dinosaur. And when I saw, being on the time I was on the commission, we would see about once a year somebody would get caught with this rule. And even though I didn't agree with the rule, but it was the rule, and so we had to enforce it. I think it's just kind of time to move this rule on out. Sounded like everybody was pretty much in agreement with the public comments too, so it doesn't look like there's any negative comments about this at all.
Thank you, Mr. Wood. Does the commission have any response to that statement? Okay. Next, I will move forward to the comments for the criminal convictions rule changes. The first comment is from Mr. Guy Ritchie. He states, I would have preferred to share my opinion in public at the board meeting, but unfortunately, I will be out of town. That being said, I am thankful for this avenue with which to communicate with you. Here are my thoughts. Someone that pleads guilty to or is convicted of a felony is sentenced to punishment by a court. Unless I am mistaken, those sentences generally consist of incarceration, fines/penalties, community service, or some combination of such. If the court wanted an individual to lose all ability to become gainfully employed for some period of time, that too should be included in their sentence, spelled out and defined. Otherwise, their sentence isn't really their punishment, but rather just a part of their punishment with another component that cannot be fully known or defined hanging over them for an indeterminate period of time. I believe that once a person has served their sentence and paid their debt to society, they should be wholly restored as a citizen, period. It is generally known that recidivism rates are lower amongst people who are employed and able to provide for themselves compared to those who cannot. Truth be told, there is no way to know if someone is rehabilitated or not, and there never will be. But it certainly should not be within the purview of a group of realtors, random government employees, or business owners, etc., to make such a determination. Those people are comprehensive, unqualified to do so. I believe if a person has done their time and passed all the exams and requirements as the rest of us, that person should be granted a license just the same. If the intent is truly to give someone a fresh start, then let's remove the obstacles and let them get on with it. Thank you for your time. Do we have any response from the commission in regard to this comment? No response from me? Okay. I will move on to the next comment. This is from Miss Kim Young. To whom it may concern, I would like to voice my opinion on this hearing. I'm a former probation officer and have worked in the court system with a criminal justice degree. No to the Fresh Start program. We are professionals in the real estate industry. It would be like lawyers letting a criminal have a fresh start in their law offices. We are subject to laws, rules, and regulations. These folks should be allowed to go back to school to get degrees and then have a fresh start. Seems to me this is easy access with the limited amount of effort for former criminals to have access to homes and private property. Most of these folks have friends in the criminal justice system. This is not a good idea. Is there any comment from the commission regarding these comments?
So if we agreed with that set of comments, we still have to abide by state law, regardless of what we think about the comment. And Jenny, this is John Grease. I thought you were on oxygen for a period of time, but I know what you're doing now. Okay. Anna, that's my comment.
Okay, thank you. The next comment is from Miss Diane Farr. Comment states, I totally understand giving someone a fresh start. However, not when it comes to someone's money or personal assets. If you are convicted of fraud or of any felony or a misdemeanor involving theft of money, services, or property, you should not be handling the sale of someone's largest asset, their home. People lie. They lie all the time. Buyers lie, sellers lie, agents, even lenders, title companies, home inspectors, etc. But we should not be putting our clients in jeopardy with someone who has been convicted. I mean, what if they list a house worth $500,000 worth of firearms and suddenly one or two go missing? Would they suspect the agent? Probably not, but they would if they knew or find out they had been convicted prior of theft. They shouldn't have to disclose the information to potential customers and clients. I would not feel comfortable knowing that there was a convicted felon trying to help me or working for me, my opinion. Is there any comment from the commission?
Anna, to John's point, what kind of leeway do we have? I mean, what was the rule before a lot of us got here? Was they couldn't apply for a couple of years or 2 or 3 years or something, and then we went to where we made the time frame a little less because of the fresh start or something. Is that correct?
That's correct. So the previous rule barred application from 2 years from the date of the conviction or the date of incarceration, whichever is later. So that this rule would just remove the 2-year requirement. The individual, if they are still on probation or if it falls within that 10-year look back, they will still have to appear before the commission in an informal appearance capacity. And if they are rejected or not allowed to proceed with licensure, we would have to go through the fresh start analysis.
So we know where the first rule came from, ex-Commissioner Bobby Wood, and he just saw a situation where, we were getting these complaints and felt like it was antiquated and decided to change this rule. Did this rule come out of somewhere at the state level or the commission level, or how did this rule come about?
Right. So this rule came from the department following the passage of the Fresh Start Act. I consulted with actually someone from the Attorney General's office, and they saw that this provision of the rules run afoul. They don't match up with the statute. So our rule is more restrictive than we're allowed to be. Therefore, the rules were presented to the commission as a rule change. So this provision has to be changed or we're running contrary to the Fresh Start Act statute that is in place.
So I won't try to consume any more time. I know everybody's ready to go, but I feel like this one's pretty important because of those last couple of comments from the public. But so the Bar Association and the Medical Association, I would assume that you couldn't be, a felon and get out of med school, have drug convictions, and it'd be tough to get the license. So are they going to all these boards? Are we any professional board and saying you all are too strict? Because I would imagine in the past they're all as strict or more strict than the real estate commission?
Right. So this does not it's not just the real estate commission. This goes to all of the occupational licensing boards and commissions that this particular statute applies to.
So Anna, I'm going to try to sum up what my understanding and the way you've explained it to us before. So the Fresh Start Act requires us to go through an extra deliberation in order to deny an application of an ex-felon.
That's correct.
That applicant would then have a basis for appeal in court if we deny them.
So if an individual is denied because of the Fresh Start Act and they wish to appeal that denial, then they have an avenue to appeal to Chancery Court. Yes.
Okay. And the Chancery Court would hear, and we would have to defend our decision. We being counsel would have to defend the decision in Chancery Court.
Right. So we would be at that point, the commission would be represented by someone from the Attorney General's office, representing us in that Chancery Court proceeding.
Okay. So the commission still has an opportunity to deny an applicant based on their felony record.
Correct.
That applicant has a remedy in court, and we have an opportunity to respond there as well.
Correct. It does not remove your ability to deny an applicant to be licensed. It just requires additional steps and considerations that have to be taken into account for certain felonies and problems.
Okay. And Jenny, this is Commissioner Jeff Diaz.
Any other comments? Okay, I have another comment. This is from Tennessee Realtors, Angela Shields, the CEO. This letter is to serve as formal comment to the proposed change to TREC Rule 1260-01-.01, removing the requirement that 2 years pass from the later date of expiration of probation, parole, or conviction, or release from incarceration for an individual to be eligible to apply for a real estate license. Tennessee Realtors is in support of this rule change and recognizes that it will help offenders become productive members of society and reduce the rate of recidivism in Tennessee. Do we have any comments from the commission? Okay, seeing that there are no comments, Ms. Maxwell, were any written comments received by the commission office regarding these rules?
Caitlin, you're muted.
I'm sorry, no additional comments were received.
Thank you. And to my knowledge, we have no comments from the chat box. So at this time, this will conclude the rulemaking hearing. Thank you for being here today. But lastly, there are several measures I will need to adopt by motion and roll call vote as required by TCA section 4-5-222. So we will need to first adopt the hearing language of the advertising rule as written. So that was the language that I read earlier in the red line. That will be removing property owner without authorization must be evidenced by a statement on the listing agreement or any other written statement signed by the owner, so that the rule may now read, no licensee shall advertise property listed by another licensee without written authorization from the listing agent or listing broker.
Is there a motion?
So moved.
Joan Smith makes a motion to approve. Jeff Diaz seconds that motion. Discussion. Okay, I hear no discussion. Anna, is this Caitlin's turn to call the roll, or how do you do it at this point?
Caitlin, it's really up to you. If you want me to call roll, I can, or.
I'm happy to call it.
Okay.
Joe Begley,
Yes.
Jeff Diaz,
Yes.
DJ Ferris,
Yes.
Vice Chair Marsha Franks is absent. Steve Glenn,
Yes.
John Moffitt,
Yes.
Joan Smith,
Yes.
Stacy Torbett,
Yes.
John Grease.
Yes. All right, that motion passes. Anna?
Okay, next we'll need a motion to adopt the language for the criminal conviction rules that we have already stated before. Would you like me to restate that, or? Okay, great.
There's a motion. Is there a motion? Jeff Diaz makes a motion, Steve Gwynn seconds. Discussion. Since there is no discussion, Caitlin, please call the roll. If you're in favor of the motion, vote aye.
Joe Begley,
Aye.
Jeff Diaz,
Aye.
DJ Ferris,
Aye.
Steve Glenn,
Aye.
John Moffitt,
Aye.
Joan Smith,
Aye.
Stacy Torbett,
Aye.
John Grease.
Yes. Okay, that motion passes. Anna?
Okay. Next, I will need to read the regulatory flexibility addendum for both sets of rules. Pursuant to TCA sections section 4-5-401 through 4-5-404. Prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. The statement reads as follows. The proposed rule does not directly affect small businesses in the real estate industry, as this is a minor advertising amendment. Therefore, the impact, if any, would be a positive impact on small businesses and will open opportunities to other small real estate industry businesses to attract new customers. The proposed rules would require minimal, if any, costs for compliance. Furthermore, the proposed rules may have an impact on small businesses and consumers, but this impact is minimal for both groups. An exemption of small business from these requirements would not be beneficial. As these proposed rules are relaxing advertising standards, small businesses would benefit and not suffer any foreseeable detriment. If anything, small businesses may benefit as this rule may allow for more individuals to enter the workforce. The Commission knows of no other less burdensome, less intrusive, or less costly alternative methods of achieving this purpose and objectives of the proposed rules. The Commission knows of no similar rules or regulations. I will now need a motion to adopt the regulatory flexibility addendum for amendments to Chapter 1260-02.
So moved.
Motion by Mr. Diaz, seconded by Mr. Begley. Did we cover both rule changes in this motion, Anna?
Sure. I'll read the second one. This is the regulatory flexibility addendum for changes to Chapter 1260-01. The proposed rule does not directly affect small businesses in the real estate industry. Specifically, the rules are designed to ease initial entry into the profession. Therefore, the impact, if any, would be positive impact on small businesses that are under the purview of the Tennessee Real Estate Commission. The proposed rules will require minimal, if any, costs for compliance. Furthermore, the proposed rules may have an impact on small businesses and consumers, but this impact is advantageous to both groups, allowing more individuals to enter the profession. may provide an increase in the amount of goods and services available to small businesses and consumers. An exemption of small business from these requirements would not be beneficial, as these proposed rules are designed to ease the entry restrictions for certain individuals impacted. Small business would benefit and not suffer any foreseeable detriment. If anything, small businesses may benefit, as this rule may allow for more individuals to enter the workforce. The Commission knows of no other less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of these rules. The proposed rules may be similar to other regulations within the department, as the Fresh Start Act impacts all regulatory boards attached to the department.
Okay, Joe and Jeff, you're okay with your motion covering both of those statements? Okay. Any comments? If not, let's vote. Caitlin?
Joe Begley? Jeff Diaz?
Yes.
Jay Ferris? Jay?
Aye. Sorry.
Steve Glenn?
Aye.
Moffett?
Aye.
Joan Smith?
Yes.
Stacy Torbett?
Yes.
John Reese?
Yes. Okay, that motion passes. Anna?
Okay, next, we will need to adopt the impact on local government statement, which is pursuant to TCA Section 4-5-228. This statement for both Chapter 126002 and Chapter 126001 reads as follows. The Tennessee Real Estate Commission foresees no impact on any local governments.
This covers both rule changes.
Yes.
Is there a motion to approve that statement?
So moved.
Jeff Diaz, seconded by John Moffett. Discussion. Let's call the roll, Caitlin. If you're in favor, vote aye.
Joe Begley?
Aye.
Diaz?
Aye.
DJ Ferris?
Aye.
Steve Glenn?
Aye.
John Moffett?
Aye.
Joan Smith?
Aye.
Stacy Torbett?
Aye.
John Reese?
Yes, that motion passes. Anna?
Okay, I will now need to read the additional information required by the Joint Government Operations Committee. I'll read both statements for both sets of rules. Section A states, provide a brief summary of the rule and description of all relevant changes and previous regulations effectuated by such rule. The response is the proposed rule is an amendment to the advertising rules set forth by the Commission. The rule amends one of the general principles. Previously, the rule required licensees to obtain written permission from the owner to advertise the property listed by another licensee. Now the rule requires written authorization not from the owner, but the listing agent or listing broker. Next would be Section B, a citation and brief description of any federal law regulation or any state law regulation mandating promulgation of such rule or establishing guidelines relevant thereto. The response is there are no federal or state laws or regulations mandating promulgation. Subsection C reads the identification of persons, organizations, corporations, or government entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. Statement reads as follows. The proposed rules would affect current and future real estate licensees. Real estate licensees that advertise other licensee listings will support the adoption of this rule, as this amendment facilitates this practice. Some consumers may reject this rule if they wish to have this additional permission to be stated specifically in writing. Section D states identification of any opinions of the Attorney General and reporter or any judicial body that directly relates to the rule or the necessity of promulgating such rule. The response to this question is there are no known opinions of the Attorney General and reporter or any judicial rulings that directly relate to this rule. Subsection E request. Sorry, one moment. Subsection E requests an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget, or $500,000, whichever is less. And the response to this question for number E is there is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from the promulgation of this rule. Next, I will read in the information for the second set of rules for criminal convictions. Subsection A, the response is the proposed rules in response to the enactment of the Fresh Start Act, Tennessee Code Annotated Section 62-76-104 that became effective on July 1st, 2018. The rule removes a previous requirement that prevented individuals convicted of any felony or misdemeanor involving theft of money, services, and property from eligibility for examination or licensure unless 2 years of the date of expiration of probation, parole, or conviction, or the date of release from incarceration, whichever is later in time. Furthermore, the rule narrows the individuals required to appear before the Commission for licensure consideration due to a criminal conviction. Currently, the rule requires all individuals convicted of any felony to appear before the Commission. To comport with the Fresh Start Act, this requirement is narrowed from all felonies to those individuals convicted of Class A, B, or C felonies, as these felony classes have a rebuttable presumption that the conviction relates directly to the fitness of the applicant engaged in the applicable occupation, profession, business, or trade. Subsection B, the response states there are no known federal laws or regulations mandating promulgation. However, the proposed rules are required to comply with current state law, the Fresh Start Act, which is Tennessee Code Annotated Section 62-76-104, which went into effect July 1st, 2018. The rule makes the necessary changes to align the rules of the Commission with the intent and requirements of the statute. Subsection C, the response is the proposed rules would affect future businesses that the Fresh Start Act is designed to specifically aid in their licensure process. Future licensees. The Commission does not foresee a particular segment of opponents to this rule. Subsection D states there are no known opinions of the Attorney General and reporter or any judicial rulings that directly relates to this rule. In the subsection E, the response is there is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from the promulgation of this rule. So we will need a motion to adopt the additional information for the Joint Government Operations Committee.
So moved. John, you're muted.
So could you hear me say, damn it, Jeff? I just was curious. Sorry about that. Okay. So if you're in agreement with the statement that Anna just read, would you make a motion to approve that statement so it can be sent to the Joint Operations Committee? Jeff made the motion, Joan seconded the motion. Now discussion. All right, Caitlin, let's call the roll.
Okay, Joe Begley,
Yes.
Jeff Diaz,
Yes.
DJ Ferris,
Yes.
Steve Glenn,
Yes.
John Moffitt,
Yes.
Smith,
Yes.
Casey Twirbett,
Yes.
John Reese.
Yes. Is that it, Anna?
Yes, one more thing, really quickly.
It's not
Thank
it.
you. Thank you. Following this hearing, the rules will be put on rulemaking filing form SS-7039 and submitted to the Attorney General's office for review and approval. Once the Attorney General's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from that date of filing. This concludes the rulemaking hearing.
Okay, thank you. You've been awfully busy, haven't you? And now the state has you litigating tomorrow. Don't get it. Okay, 2 or 3 things. Let me clear up one thing. I said, have we voted on this? We're current on votes. I mentioned you can get 8 hours of continuing education for attending a full session of the Real Estate Commission meeting. Well, this session is not over today. It carries over until tomorrow. So you might have to attend more than 8 hours of education, of meetings to get 8 hours of education, but you learn so much. Number 2, Jenny, are you in a bar or where are you? I see the golf. Do you have the Masters on TV?
I am actually in my son's storage room because that's where our Ethernet hooks up.
Did you
He's
put damn it? Will you transcribe damn it into the record?
No, I will not.
Why?
I will just put off record.
Okay, thank you.
I will if you want me to.
No. I don't know what your ethical standards are. And are you with us tomorrow or do we have a different court reporter?
I am here. I will be with you tomorrow.
Perfect. And we start at 8:30 Central Time. Well, Anna, one last question for you. Will Ella and Quincy be with us tomorrow?
I really hope not. I think they might be spending some time in their crates.
No,
tomorrow.
don't do that. I'll give them some treats. Tell them they did good.
Why?
Just kidding. All right, we're going to stand in recess till 8:30 tomorrow morning. Thank you all for your attendance. Good night.
Thank you.
Thank you.
Thanks, everybody.